All right. I think we're ready to start. Ms. Rivers, good morning.
Good morning.
Ready to go?
Yes, Judge, I'm ready.
Great. Okay. For those of you in the courtroom who are defendants on this morning's calendar, it's the final plea date for you, which means it is your last opportunity if you're going to resolve your case by way of a plea, to enter that plea and have the ability to withdraw or back out of the plea if you don't like the sentence you get. Usually you get the sentence that is negotiated and you ask for. Sometimes it doesn't play out that way. And if the sentence that I impose is more severe than what your lawyer asked for on your behalf, today and today only, you can say no thanks and we just move to trial. After today, you can certainly enter a plea. Pleas happen all the time, but you would not have the ability to withdraw that plea if you were dissatisfied with the sentence. That's the plan. Many of the cases on today's calendar are on our August trial calendar. One is coming up next week, and then the last is in September, but we'll work through that. All right, let's figure out what we're doing. Is Ms. Bennett here? Hey, Ms. Bennett.
Hi, how are you?
I'm all right. Ms. Rios, your client. I don't see our white collar people. You're the white collar person today. Mike, you are wearing a white collar.
Sure.
All right. And then is Ms. Taylor here? There's Ms. Taylor smiling as always. Let's see if Ms. Cabrera is on. I don't see her. Ms. Nelson, do you have an update as to where Ms. Cabrera is? We'll wait to hear from Ms. Nelson. Oh, she's looking for her. Okay. Mr. Abate, do you want to wait until we have Ms. Cabrera in the mix to address Ms. Bennett and Ms. Taylor, our co-defendants in one of the cases?
It's up to your honor.
I'll wait. I think it's just more efficient that way. So let's turn to Mr. Thomas, Jael Thomas. Good morning, sir. Ms. Rios, that's your case, and Ms. Willingham, but I think she's in trial.
She is. My understanding was that maybe Jordan was going to handle it. He just texted me that he's en route.
Okay, well, we'll hold on for that. So we'll talk about your case in just a couple minutes once the Wright prosecutor gets here. Mr. Galaro, I owe you a ruling on that, so we'll preserve his final plea rights, and we can tell him that. He's in custody. His co-defendant, Mr. Romero? Right there. Okay, we're waiting on your lawyer, Ms. Cabrera. It's got two cases on this calendar, so we'll sit tight on that, okay? Do you need an interpreter?
Yes, sir.
Okay. So Ms. Nelson, if we could see if we can get Mr. Lares, that'd be great. A lot of moving parts this morning. Mr. Deloach, let's move all the way up there.
He's fine, Judge. He's in custody.
Yep.
If we could come back to this one, I have him all.
Okay, great. Well, he's here, so you should chat with him. We've got Mr. Miller. I'm assuming nothing changed from last night, unless like there's a probation offer that snuck through.
I did get an offer to me to relay, but there's nothing that's going to, not going to be resolved today.
Okay, we'll get all that on the record. And then we get to Ms. Rivera, Divinity Rivera.
Judge, she's on the Zoom.
Okay, I see there is a Divinity on the Zoom. Okay.
Yes.
I regret to inform the court, this is going to be a conflict. Thanks to Ms. Nix for discovering that. One of my colleagues represents the alleged victim in this case and has had the case longer than me. So yes, I did explain to Ms. Rivera that she'll be getting a new attorney.
Okay, Ms. Rivera, can you please turn your camera on?
Yes, give me 1 second.
Okay.
Good morning.
Good morning. How are you? Are you able to hear me?
Yes, can you hear me?
I can. Thanks for turning the camera on. I just want to, you've already heard Ms. Wood say it, but I'm going to mention it again, just make sure you understand. Ms. Wood has been working hard on your behalf for many weeks now and learned only recently, she didn't realize it, but her office represents, and let's not keep it vague. Oh, that's not what I wanted to do.
Brandon Thomas. Brandon Thomas.
Brandon Thomas. So Brandon Thomas is the person you allegedly did something to in this case. He is a defendant in another case, and one of Ms. Wood's colleagues represents Mr. Thomas. Normally, that really wouldn't be your problem, but because Mr. Thomas's case is a little older, or at least the lawyer from Ms. Wood's office has represented Mr. Thomas a little bit longer, then that lawyer is going to stay on with Mr. Thomas, and you are going to be appointed what we call a conflict defender. So another real good lawyer, but someone who doesn't work with Ms. Wood, and so won't have any conflict issues.
Okay.
And that lawyer may actually have just walked into the courtroom, but not necessarily. I mean, someone did just walk into the courtroom. Ms. Cabrera is the person who generally takes the conflict cases in our courtroom. I can't commit that she's the one who will be, but I'll certainly have a conversation with her. So we're going to pause your case. Today was the day you needed to tell me through your lawyer, we're working it out, or I'm going to maybe try a plea, or we're going to trial. But Ms. Wood has to step back, and a different lawyer will need to step in. And that lawyer, of course, needs to get to know you, know more about the case, so that she or he can have that important conversation of how do we want to try to work this out? Is it a trial? Is it a plea, or what? Does that make sense?
Yes, it makes sense.
Okay. I'm sorry that this is happening late in the game. It's not really anyone's fault. The defendant, the alleged victim in your case, has a pretty common name, so it doesn't jump out like, oh, we represent that guy.
Yeah.
You know, if it was Ichabod Crane, they'd remember that. Of course, there's only one of those guys.
Yeah.
So I'm going to get a new date for you to come back here, and back here could mean virtual. Are you in the Atlanta area, or do you live far away?
No, I'm in the Atlanta area. I just don't have a car right now.
Okay, and it's fine that you're appearing this way. There may come a time where I need you to come to court, but I think our next session will be what we call an inquiry calendar, and that'll be a chance for me to hear from you and your newly appointed lawyer about how ready you guys are to do this final plea situation or put the case on a trial calendar. Okay?
Okay.
Do you have any questions?
No, I don't have any questions.
All right, let me make sure we've got good contact info for you. The address I have is on Campbellton Road. Is that correct?
Yes.
There's no apartment number. Is it just a house on Campbellton Road?
Yes.
Okay, great. Then you'll continue to get notice there. I'll ask Ms. Wood to share the contact info she has. She may have a cell phone number or an email address with the lawyer who does get appointed to represent you, so that that person can reach out to you directly, and we will take it from there.
Okay.
Ms. Wood, anything else on behalf of Ms. Rivera?
No, Your Honor, thank you.
Okay. Do we have one of these real odd situations where Ms. Rivera is the alleged victim in Mr. Thomas's case?
No, Judge, it's a different person. That's one of the reasons my colleague in Judge Carnicel's courtroom was really eager to keep that case.
Okay. It's a victim case. The victim is just not Ms. Rivera.
Yes.
Interesting. Okay. All right. So Ms. Rivera, you are free to go. The lawyer who gets appointed to your case will reach out to you soon. Okay.
Okay, thank you.
All right. Thank you, Ms. Nix, for catching that. Ms. Cabrera, how do we figure out, does that run through Mr. Luemba?
So once they put in the paperwork, to request that it be assigned to a conflict defender, it's probably gonna come to me. I just can't ever say anything or make a move on it until it pops through.
Understood. It's not like we don't have a conflict defender's office in that way anymore. So, so that's something Ms. Wood needs to do.
So whenever it happens, when they send that, request out, just put me in the email, and then I'll tell him that I think this is coming.
Okay.
And then he knows to pay attention or to tap them to say, hey, is this coming, before it makes it back into account.
Okay, sounds good. We will handle it that way. And then, last on the calendar is Ken Wright. He should be in custody.
Yes, Judge, I do anticipate this being a final plea hearing, although I need to speak with him and his family before we actually do that.
Okay, and we have Ms. Clark on the call. Great, okay. So you're gonna talk with Mr. Wright. You're also gonna talk with, Mr. Deloach.
Yes, Judge.
All right. Now Ms. Cabrera is here, so let's go back to Ms. Bennett's 2 cases and Ms. Taylor's 1 case. I'll start with you, Ms. Rios. What are we doing with Ms. Bennett today?
Entering in, this being not guilty, there's some information that she has to provide to me.
So she's already entered a not guilty plea because we arraigned her a while ago. So she is going to reject whatever offer we get on the record from the state
Yes,
and have both her cases moved to the trial calendar.
yes.
Okay. Then you should, we'll get that on the record in just a sec. Ms. Cabrera, you represent Ms. Taylor. Same situation. What are we doing?
I need to speak with her. I sent her a couple of emails, but I haven't heard back, so I don't know her position.
Okay,
So if I can speak to her real quick, one, to make sure she got the emails,
Yeah.
two, to see what her position is.
Good.
And I'll be able to give an announcement on that one. And I have Mr. Silva.
and he's right there. Do you have an offer in that case?
Well, I'm gonna talk to the state real quick.
Okay.
He did tell me something, and I didn't get a chance to speak to Ms. Nix. We'll do it right now.
Okay, great. Then what we're gonna do is we'll do the final plea hearing for Ms. Bennett. Mr. Abate can handle that. You can speak with Ms. Taylor. You can also speak with Mr. Silva. We're ordering up Mr. Lares, the interpreter. You and Mr. Silva may be able to have a basic conversation, but he's asked for an interpreter to be here. And so as soon as, I assume it'll be Mr. Lares, as soon as he gets here, then you guys can talk in even more detail.
Okay, I'll speak with Ms. Nix first, and
Okay.
then I'll speak with Ms. Taylor. That way, when Mr. Lars is up, I'll be ready.
Great, okay. So Ms. Bennett, if you would come on up to the podium, please. All right. Let's get on the record in your 2 cases. It's 23 SC 189687 and 23 SC 189690. Ms. Rios, you are going to share with us, there's a discovery concern you have?
She has some information that she's giving to me, a whole binder of it that might make a difference on what the state is offering or what the state even goes forward with the case.
With both cases or just one of the cases?
One case. There's the other case, I don't believe she gave me any information for that case, but
But I have it. So then that would be for that case as well.
okay, she has information for both cases that I just became aware of. So we kind of want more time to be able to negotiate with the state with that new information.
Okay, so a couple things. I've heard this before, that Ms. Bennett's got information, not from you, but Ms. Bennett has long said, I've got this information, I've got this information. And if she's gonna give you something, that's great, and you can share it with the state. I'm not extending the final plea date. This is the final plea date, and Ms. Bennett's case will go on our September trial calendar. So that's still a couple months that you will be able to negotiate, probably not with Mr. Abate long-term. I'm guessing it will go back. Are the white collar people just busy today, or you're adding to your portfolio?
I'll be adding to my portfolio
You're keeping this case?
for now.
Okay, well then you will be negotiating with Mr. Abate.
Solomon's gonna assigned to trial division as we've lost some people recently.
Okay. Oh, and what about the guy who's the brother with the defense attorney?
He is in case intake.
Okay. Is there a white collar unit anymore?
I'm in.
Hey, well, we've got the right lawyer here for the state. So you're gonna get more information. Let's hear from but it's not that the state owes you information.
No, not that I'm aware, no.
Got it. Okay. Mr. Bata, if Ms. Bennett wanted to resolve her 2 cases today, what would the state be recommending?
The
Excuse
recommendation,
me, Judge. Mr.
Yes.
Put your microphone on, please.
I'm sorry, Ms. Rivers.
Thank you.
The state's recommendation for both cases would be 20 years to serve 6 years. And she's an ANC recidivist, and we would not be withdrawing the recidivist notice. She would need to pay $92,750 in restitution. Mr. Salmon recommended 500 hours of community service, and that she not work in any financial capacity while on probation.
Okay. And that would resolve both cases together.
That's correct, Judge.
Okay, so Ms. Bennett, I want to make sure you understand what I heard. If you were to enter a plea today, the state would recommend, this doesn't bind me, but it's what the state would recommend, that you serve 6 years in custody. Because of your criminal history, those would be non-parolable years. You would do every day of the 6 years. That would be followed by 14 years on probation. Pretty sizable amount of restitution, 92,000, and then a bunch of community service once you're on probation, and you wouldn't be able to hold a job in the financial services industry. Do you understand what the state would be recommending?
I do understand what the
Okay.
state would be recommending. However, I would not take that knowing that all this is false.
Okay, all right. So it sounds like you would like to give Ms. Rios a chance to look through the information that you say is
I want to go to trial.
in these binders and ultimately go to trial.
Yes.
Okay. Oh, you've got a trial date. It is in September.
Okay.
And I just need to make sure that you understand that after today, if you decide to enter a plea,
I won't enter a plea because the allegations are false.
okay, but I need to be able to finish my sentence, and then you can tell me again that the allegations are false. If you decide to enter a plea after today, you've got a right to do that, and we'll have that plea hearing. The one thing that's different after today is that if I'm making the numbers up, maybe Ms. Rios advocates for a straight probation sentence for you. Judge, it needs to be a lot of probation so she can pay this money back. So we think it should be 10 years probation, but no jail time. Here are a bunch of reasons why Ms. Bennett should stay out, be with her family, et cetera, et cetera. If I disagree and I sentence you, and again, I'm making this up, to 1 week in jail, that 1 week is more than no jail. Today, you could back out of your plea if my sentence was more than what Ms. Rios asked for. After today, if you enter a plea, you are stuck with whatever sentence you get. Just like if you go to trial. If you go to trial and a jury says, despite your evidence, that you're guilty, you don't get to then say, oh, I don't like that sentence. You're stuck with whatever sentence you get. Okay?
Okay.
All right. As long as you understand that, then we will keep your case on the September 5th trial calendar. You'll get notice for that. Ms. Rios is going to be in touch. I encourage you, if you do have these materials, to get them to Ms. Rios as soon as possible. I will not be continuing the trial because Ms. Rios says, it's September 4th and I just got this binder of stuff. That's on you to get to her. Okay?
No problem.
Any questions for me?
Not at all.
Ms. Rios, anything else on behalf of Ms. Bennett?
No, Your Honor.
Mr. Abate, anything else from the white collar unit?
No, Your Honor.
All right. Thank you, ma'am. You are free to go.
Thank you.
Always trying to learn new things.
Yep. So are there any others that we want to handle right now? I know Ms. Cabrera needs to talk to a few people. Mr. Hiles just turned his microphone on. Should we handle Mr. Miller so Mr. Hiles can go?
Yes, I would like that if possible. I don't necessarily expect him to take the offer with the short notice.
Okay, well, it's all about your schedule. So let's bring Mr. Miller out, please.
I haven't had time to relay the offer.
Oh, you haven't had time. Okay, so let's do this. I we're not gonna hold you for a ton, Mr. Hiles, but the lawyers need to talk to folks, and that late offer is on you and not on Ms. Rios. So I don't mind that you gotta cool your jets for another 5 minutes. I'm gonna take a quick break so lawyers can have a huddle, take a seat. Then when we get back, the first thing we'll do is unless he says yes, if he says yes, we'll wait to take that plea. We'll do it this morning, but we might take a few things ahead of that, okay?
Understood. I'm around.
Thanks. Yes, sir. No, stay right where you are. Tell me what's going on.
Well, Your Honor, I got released today.
Good.
You suddenly, but probation, I was saying, I ain't gonna say what she said, but she still said on probation. I said, well, let me go back down and check with the judge.
Okay, so how about this? You take a seat, and if Ms. Wood knows what's going on, I'm gonna have a quick conversation with Ms. Wood and Ms. Nix, and we'll see what we can do. I'm glad you got released, okay? Don't go anywhere.
Yes, sir.
All right. All right, so we'll take, I don't wanna rush anyone. Is 5 minutes enough? Take a 5-minute break. When I come back, we'll see if we're ready with Miller. Maybe we can do some of Ms.
The announcement, Mr. Silva, I don't know where Carlos is here.
He is.
So Mr. Silva, and then I can talk to him and Carlos while you're gone.
Okay, well, but if he's saying no to the final plea offer, we need to get that on the record. And,
But we're asking for something different.
okay, why don't we just get it on the record when I come back?
All right.
And we'll do Mr. Miller real quickly, and then since we've got Mr. Lyons here, we'll do that second, okay? But why don't you start using his services now? All right, and I will mute the podium so people can speak freely. Okay, for everyone out there in listening land, we didn't talk about anything interesting while the podium was muted. Ms. Cabrera was sharing with me her scheduling situation for the 2 weeks of the trial calendar, and it is likely that we will continue positions 5 and 6 from our July trial calendar. Ms. Nix, was there anything you wanted to add about the Romero Silva case and Galaro?
No, sir, I agree with the request to continue so that we can get the order on the suppression hearing. And because that kind of will affect, even though it's not directly affecting, I guess, it's not in Mr. Silva's case, it is going to affect how the state proceeds with the case.
Got it.
Are we gonna bring him up?
I'll tell him that. Yeah, we were just addressing, so Mr. Larios can go. Mr. Romero, do you have any questions for me? You understand that your trial is being continued, meaning it will not happen in July. It will happen later than July.
So I had a hearing date on July 2nd schedule, so would that happen or would not?
Canceled.
Until new date that you will provide?
Yes. And let's make sure we've got a good address. Ms. Cabrera, when you speak with Mr. Romero, are you able to have a basic conversation like you need to come to court? Okay. Bowhead Court in Fairburn? You'll get something in the mail telling you when you need to be back. It will not be until August or September. Do you have Ms. Cabrera's phone number?
He talked to me yesterday.
Good. She will be reaching out to you well before I send you something. Anything else?
No.
All right, he is, do you need to speak to him anymore, or is he free to go? Okay, he's free to go. Thank you, Mr. Larios.
Thank you. All right, I'm gonna step out and I'll.
All right, we do need to talk about Ms. Taylor.
Gonna go and talk to her.
Great.
You said 5 minutes, so I came back and I didn't.
I know, and then it wasn't 5 minutes, because Sarge's like, hey, you can't leave, so I was trapped back there. Can we do Mr. Miller now? Please, and then we'll do Mr. Galaro. How do you say his last name?
I think it's Galaro.
Gallardo? Gallardo.
I'm sorry that.
Thank you. I just got an email from Ms. Nelson about Mr. Bell.
Oh, great, I was typing you one. If I forward the order to you, can you print a copy for Mr. Bell? Or I might have sent him that email.
So I think that's what,
I think I might have sent it to her too.
you sent it to Officer Evans and Ms. Nelson, and now I've got it. Okay, and it says terminated, so we'll talk with Officer Evans, and Mr. Bell, you're gonna sit tight. We're gonna figure this out, okay? Don't look so pained. We'll get a good result today, okay? Well, and that's why you came back. You know where to go for answers. Mr. Miller, come on up to the podium, please.
She lost her right beside you.
All right, let's get on the record with Mr. Miller. It's 24 SC 0000768. I feel like we were just together. Now I get to see you in person. Mr. Miller, today's your final plea date. We spoke yesterday at your bond hearing. You appeared virtually, and your lawyer, Ms. Rios, told me, I don't have an offer to relay to Mr. Miller. Sounds like Mr. Hiles, the prosecutor, who is on the screen now next to you. Can you angle that screen up a little bit, Deputy? We're catching Mr. Miller's chin. There we go. Great. Thank you so much. Mr. Hiles did ultimately get an offer to Ms. Rios. It sounds like she sent it to you. She forecast to me before she went to talk to you that it was not likely something that would resolve the case. But before we get there, Ms. Rios, do you believe that you have all the discovery in this case?
I believe so. I know he said the supplemental discovery is for something else, not actually pertaining to the actual
Case in chief.
Yes.
Right. What Mr. Hiles told us yesterday is that there may be some 418 material that relates to those much older cases that maybe comes in, maybe doesn't. But if he can't get his hands on that, that's not a reason not to go forward with the trial. That's something that would bolster the state's case. It's in no way exculpatory.
Yeah.
And he's working on getting that. And if he does, he'll get it to you, and we'll see if you've got enough time to process it. Mr. Miller's case is on for our August trial calendar, so he'll be there then. Mr. Hiles, what is the state's offer if Mr. Miller wanted to resolve his case today?
The offer, Your Honor, would be 25 to plead to the indictment with an aggregate sentence of, on the indictment to be 25 years to serve 15 years in custody with the balance on probation, and then a consecutive 5 years suspended on the possession of firearm during commission of a felony charges. Special conditions being no contact with criminal street gang members, no contact with victims, listed victims in the case, and no participation in gang activity, no firearms or replicas. And if he were to elect to enter a plea, the state would not pursue the recidivist,
Notice?
Yes. And he is an A and C recidivist.
Okay, so the plea today would be 15 to serve, but they would be a parolable 15.
Yes.
Because I don't think I'm looking at these charges, it's not an armed robbery or anything that's non-parolable. But if Mr. Miller goes to trial, there is already on the docket a recidivist notice, so that whatever sentence, if he's found guilty, big if, but if he's found guilty, whatever sentence he gets, it would be non-parolable.
That's correct. I'm going to refile it and update it, make sure everything's good, but yes.
Okay. All right. Mr. Miller, I'm hearing Mr. Hiles say that if you wanted to enter a plea today, it would be a plea to all the counts in the indictment, and the state would recommend 15 years in custody. You get credit. I think you've been in almost 450 days, more than a year. You get credit for that year. And these charges, if you're not being treated as a recidivist, meaning someone who's got some prior convictions, they're parolable. So you'd be eligible for parole at some point during those 15 years, be followed by some probation and a little bit of a suspended sentence. Do you understand that the basic outline of what the state would be recommending?
Yes, sir.
Okay. Today, if you entered a plea and I were to sentence you to more than what Ms. Rios asked for, she might ask for something less than 15. If I were to sentence you to more than what Ms. Rios asked for, then you could withdraw your plea. So let's say hypothetically she asked for 8, state says 15. I say, gosh, given Mr. Miller's history and 2 people shot here, I think 10 years is the right sentence. Judge, I was willing to do 8. That's what Ms. Rios advocated for. No, thank you. And you come back out. And no harm, no foul. Jury would never know that you tried to enter a plea. After today, you still can work the case out. And that may be what Ms. Rios advises you to do. The difference after today is you cannot withdraw your plea if you are dissatisfied with the sentence that I impose. So it's sort of like what happens after a trial. If you go to trial and a jury finds you guilty, you don't get to back out of the sentence if you don't like the sentence, because the jury's already decided you were guilty. Does that make sense?
Yes, sir.
Okay, so understanding the state's recommendation, they're going to recommend 15 years to serve, parolable years. Are you interested in going forward with a plea today or getting that case on that August 8th trial calendar?
Getting it on the August 8th trial calendar.
Well, it's on it, and that's when I will see you next, if not earlier. If something happens with your case where we need to have another conversation, we may need to have a hearing on some of this evidence the state's trying to find about some of your older cases. We'll bring you back for that, so you'll be here for that. At the latest, you'd be here when we call that calendar for the August trial calendar. All right?
Why my old cases keep getting heard when they say case closed? I served a whole 20 years off of it.
So it's a fair question, and Ms. Rios will probably share your frustration with that. But there are some situations where if you go to trial on these new charges, the state is allowed to tell the jury about some of the things that happened in your past. They have to convince me that there are certain rules that apply that make that okay. But that's what Mr. Hiles is if he can get his hands on that evidence, he's going to argue that I need to let the jury hear about those other things. Ms. Rios will say, that's not fair. That's what something that happened in the past. And he already did his time. Let's focus on this situation. And I'll hear both sides. And mostly I'll look at what does the law say ought to happen in a situation like that. But I will tell you, that is sometimes what makes a defendant enter a guilty plea. He says, dang, if they're going to hear about all that other stuff as well, this case here, man, it's not so great. They say I shot this guy, I've got an alibi, or maybe it was self-defense. But if they're also going to hear about this other thing and this other thing, maybe I just need to work it out. So I will let you and Ms. Rios know before trial if this.
I don't feel comfortable going to trial with her, though.
Why are you saying that?
I don't get visits and then hard to get my wife contact her. She don't call back, like attitude. Like I don't feel comfortable with her. Like no disrespect in there. Like when I got back to the jail yesterday, I wrote the bar.
Okay.
Yeah, there's a communication breakdown. I have visited Mr. Miller several times, but there is some communication issues.
Okay. Well, we may need to talk one more time before trial, but I need to tell you that standing next to you is a very accomplished lawyer who has a career representing criminal defendants. There's nothing special about your case other than that it's your case, which means it's important to you. Ms. Rios is not treating your case with any less care or attention than anyone else's. And as your trial date gets closer, her focus on your case grows greater, but she has more than one client. Just like if you hired an attorney on your own, that person would have more than one client. You are free to hire any lawyer you want if you can afford one. You need to let that lawyer know, if your family is out there talking to a lawyer, that lawyer needs to be ready to go with trial in August. I'm not going to delay this because you bring in lawyer X in 3 weeks and that person says, whoa, look at all these counts. There's no way I can be ready. You need to be telling that other lawyer, if you're looking to hire one, that he or she needs to jump in ready to go. But I encourage you to work with Ms. Rios. I suspect she will be seeing you more than she's seen you in the past. She also, before you have more to say about Ms. Rios, she is not new as a lawyer. She is not new to criminal defense, but she recently was transferred into my courtroom from a different courtroom. So she is newer to your case. You've been in jail for 400 and something days. Ms. Rios wouldn't have been the person to visit you on day 50, on day 100, on day 150, on day 200. It wasn't her case then. Now, there may have been a lawyer who should have been visiting you, and you should be frustrated that you didn't see a lawyer then. That's not Ms. Rios. She's only been assigned to your case for the last 50, 60 days. And so if you're thinking, dang, I've only seen her a couple times, that's actually not a bad ratio for Ms. Rios having been on your case for only that long. But if you were to call the public defender's office 100 days ago or 200 days ago and say, send me my lawyer, they would not have sent you Ms. Rios because she wasn't your lawyer then. Last thing I'll say about this, and then I'll let you have the final word because it's your case. I have no concern about Ms. Rios's ability, A, to provide you with effective representation, or B, to know the facts and circumstances of your case. She is newer to it, and so you might say, well, what about this thing from 2 years ago? And she may say, let me look into that. She will look into it, but I have no concern about her ability to be ready in August, having wrapped her arms around all the facts and circumstance of your case. But she is newer to the case, and she is not the one who would have come to visit you a year ago. That doesn't mean someone shouldn't have visited you. I'm not making excuses for the public defender's office, but I am letting you know that Ms. Rios is newer to your case. End of my sermon. What do you want to say? You said what you wanted to say. All right. Mr. Hiles, anything from the state?
No, Your Honor.
All right. The sooner you get your hands on those other files, the better. The longer it takes, the less likely it is that there would be time for everyone to meaningfully assess those. Okay?
Understood.
I figured you understood. All right. Thank you, Mr. Miller. We will see you soon.
Your Honor, may I please be excused?
Yes, sir.
Thank you.
All right. Ms. Cabrera, I saw you and Ms. Taylor come back in. Are we ready to have the final plea discussion with Ms. Taylor?
Yes.
Ms. Taylor, Ms. Cabrera, come on up to the podium, please. All right, let's get on the record. In your case, Ms. Taylor, 23 SC 189-690. You are the co-defendant to Ms. Bennett in this case. Ms. Cabrera is your attorney. Ms. Cabrera, have you received all the discovery in the case?
I have.
So no discovery issues. Mr. Abate, you shared an offer for Ms. Bennett, but she has two cases, so it may be a different, and she may not be similarly situated to Ms. Taylor. What is the state's offer to Ms. Taylor should she want to resolve her case today?
So the offer would be 10 years to serve, 3 years with the balance to be probated with a restitution amount of $92,750. Or she can have a straight probation offer, be 10 years with a successful, if she successfully completes the conditions of a negotiated plea, she could early terminate after 3 years if she provides a truthful proffer as it relates to the case and her co-defendant before trial. Does that make sense?
It does. Meaning she'd need to provide that proffer before trial because today's final plea. And so if Ms. Taylor were to say, I like option B more than option A, no jail involved, she wouldn't do the proffer now. And obviously she wouldn't testify now because the other trial's not happening yet. But that would be a condition of maintaining that probation and having that behavioral incentive date of 3 years out.
That's correct, Judge. And I can tell the court that this offer was made months and months ago. And I know for a fact that Miss, I call her Miss Euphemia, I apologize, but she has relayed that to her client months and months ago. And her client has neglected to respond to either one of the offers as to whether she'd like to cooperate, she wants trial. I know discovery has also been provided to the defendant through her counsel, and there's just been no communication is my understanding, which is what's kind of held this entire case up.
Got it. Well, look who we have right here, Ms. Taylor. Ms. Taylor, Well, you want to say anything before I ask Ms. Taylor what she wants to do, or she's told you what she wants to do?
Well,
this case.
No, don't worry about that.
Okay.
So she is, she's gonna be rejecting the offer of the state. I spoke with her, she acknowledges the emails that were sent to her. There were some that she did not see, and she also had a death, and so she kind of just got back on good footing as of Tuesday. So she's seeing my emails and things like that, but she did say that as far as the discovery link that was sent to her, she does not see that. So I'll send that to her again. Mr. Abadi wasn't who I was speaking to about the discovery link. They had to send it to me a couple of times too. It's a lot.
It should be, I mean, given the white collar nature, it's
Yeah,
probably not 10 pages.
Yeah, it's a lot. So when I emailed her, I needed to know, one, that she was able to even open it so that myself and the state could figure out how else to send it to her if she can't.
Okay,
So we'll go down that road again.
okay,
But she does still, and she maintained it even before we had this particular final plea, that she intended to reject the state's offer.
okay.
So that's
Both options.
correct.
Okay,
That's her posture. I still want her to be able to review everything. It does appear that there were some motions that she filed even before my representation. I sent a message to.
that Ms. Taylor filed on her own? Okay,
I sent a message to Ms. Nelson to see if there's a way that I can get them through her, because unfortunately, since I don't work for the public defender's office, I can't get them without paying for them.
I'll email, I can email them to you.
Okay, perfect.
great. I was gonna offer the same, but if Mr. Abate will do it,
You can send them to me, then it'll let me know if there's something that should be adopted and if there's something that we should do.
okay.
But whatever the next steps is for Your Honor and his calendar, that's the direction that we go in now.
Okay, well, what the no thank you means, and let me pause first and say, Ms. Taylor, I'm sorry for the loss in your family. I don't know who that person was to you, but that's always put everything else aside and deal with the family situation. So this case isn't something you get to avoid, but I'm sorry that there was some time when it was hard for you to plug in with Ms. Cabrera.
She's asking about something, she's asked before, and the state and I spoke briefly about it. She wants to know if there's any way for her to get her passport back, and so she's telling me that now.
Yeah, not until we resolve her case. I can answer that.
So how do I address that I can't do any business? I have no ID to go to a bank. I need my ID for my job, which I haven't been able to do. That is my sole source of how I take care of myself. So the state should be in some position to have a reasonable alternative, because that's my only sole source of identification, Judge.
There's licenses.
I don't have a license. I don't use a license. I
Then
don't
get a
drive.
state ID.
It's not sufficient if that's my primary source.
You have
And
options.
I sent that to her. That is one of the primary sources of how to get an identification.
Okay. Let me see if I follow. You're saying you don't want to get a,
She's talking about the list of things that you need when you go to get a state ID.
got it. So it's not that Ms. Taylor is saying, I refuse to get a state ID. I, Ms. Taylor, am willing to get a state ID, but in order to get it, I must have my passport?
I needed some primary source of something which I don't have.
No social security card, no birth certificate, or you need more than that?
You needed a lot more. I sent it to Ms. Cabrera, and we
I
had
can't remember
discussed
all of
that.
it, but I'm looking right now.
Yeah.
Certificate in the bill.
So security card, US passport card, birth certificate,
But is that an or list or?
certificate of citizenship. I'm pretty sure it's not an or, it's probably a something and.
Well, how about this? We're not going to solve it right now. We have other folks who are here for their business today. When you get a chance, Ms. Cabrera, you can send to me and Mr. Abate, you just send us the link, whatever it is. But if I see from DDS or whoever issues state IDs that the only way Ms. Taylor can get her ID is social plus one, but I would think with social.
I'm looking right now, primary ID, she has to, if she can bring her certificate, her,
Actually, I know the answer because we have people in drug court who always, they don't have passports. They've never had passports. They get their state ID because they have a birth certificate and a social security card.
I don't have a birth certificate here because I'm not born here. And
Where
I
are you
can't go
born?
to New York. I'm from New York. So I can't go to New York to get a birth certificate because I can't leave the state. It's a catch-22, Judge.
Well, except that we have folks in accountability court get out-of-state birth certificates
Well, if
all the
someone can
time.
assist me with it, that's fine. The point is I addressed it with Ms. Cabrera,
Got it.
and I'd like to hear it before the court.
Got it. All right.
It may actually not be something that has to be heard before the court.
Yeah, it doesn't. The passport stays where it stays. I am confident that if Ms. Taylor truly applied herself to this issue, she could get herself a state ID. I'm gonna stay out of that one. There aren't motions. There was something filed
Today.
Called a non-statutory judicial notice of law. And so we can get that to you. I'm quite sure what it is.
Yeah, and then I think there's a pre-indictment motion that she said she filed.
Yep, let's see. There was a motion for bond. That's it.
Okay.
Yeah, the docket is, it has 16 entries total, and that includes all the pre-indictment stuff. So
Just take whatever is filed before I got her,
No, there's a pre-indictment motion
they can send it to me.
with the first attorney, Marcia Jack or something like that, who said that he couldn't do anything because you have to wait till you're indicted. And then when the female attorney came on, she said she wasn't in a position to actually address it. So I brought it to Ms. Cabrera's attention.
okay.
All right.
Well, what I am gonna do
You can order
is
them.
this.
Two orders in.
They just haven't responded yet.
No, I'm showing you, I have two orders in. It's not that simple. Show you two. Write a check.
Yeah, this is fire check.
I'll show you. The motion to dismiss had the pre-indictment number, and then it had to be revised.
Okay. All right, so what we are doing with the case, because that was the question, is that it will stay on the September trial calendar. So it does not interfere with your July situation. It's not a calendar that's been published yet, but it is September 5th
Okay. I have a special set, I think, the 30th.
of,
I don't know, it leans into October. It's the end
Oh,
of September. and it leans
got
into
it. This is the beginning of September. So Ms. Taylor's case will be right there. And I'm handing you,
Perfect.
Ms. Cabrera, a screenshot of the docket of this case for her. So you'll be able to see every entry, and then you can let Mr. Bate know which one you want.
Awesome.
The only one that's there, meaning something that Ms. Taylor filed, is this choice of law. I'm not sure what it is.
Is that what was filed today?
Yes. It was looking a little sovereign-esque, but it is what it is.
I have a certificate of service for my motion, Judge. Why it's not there, I don't know.
Thank you, sir. Appreciate it. All right, Mr. Bate, anything else in Ms. Taylor's case?
Just whether, I guess Ms. Taylor is going to continue being represented by Ms.
Cabrera?
Cabrera. Sorry, I'm so used to calling her Euphemia. I'm sorry.
It's okay.
Fine, fine.
Well, let me ask Ms. Taylor. Ms. Taylor, are you planning on representing yourself, or are you gonna have Ms. Cabrera as your counsel?
I don't see where the question came from.
It came from.
I'm asking you.
No, but I'm saying, why did he suggest it?
Well, my suggestion, Your Honor, was based on the filings that continue to become by Ms. Taylor, and she's represented by
Right,
counsel.
generally, people don't file things on their own, they file it through their lawyer. But I'd like you to put that piece of paper down and look at me, because I'm talking to you. Are you gonna represent yourself, or is Ms. Cabrera gonna be your lawyer?
So depending on what happens with this judge, I'm gonna keep Ms. Cabrera for now.
Depending on what happens with what?
With whatever this motion list is, I don't know if
It's
if
not a
my
motion list,
document,
It's just a document.
if it's getting before the court. I don't know why. So
What is it that you wanna have before the court?
there was a pre-indictment motion to dismiss that I have proof of service with the,
There is no such thing as a motion. I know you filed it, but just so you know, I don't want you to pin your hopes on something that will get zero traction. If you file, whether you filed it or a lawyer filed it, before there's an indictment, there's nothing to dismiss. And so let's say I could find that motion. I will deny it as an improperly filed motion, not because you filed it, that's not the issue, but there's nothing to dismiss before there's an indictment.
it was refiled with the indictment number.
Okay?
So it's been refiled as well.
All right, so two things. One, you'll see the docket right there when we're done talking. And there is nothing in the docket that says motion to dismiss. But number two, even after there's an indictment, one doesn't dismiss an indictment. There may be reasons why the state's case is not strong, but the way charges go away is either the state can withdraw the charges or there is a trial. And after the state rests, your lawyer says, we move for what's called a directed verdict. That's when I would have the authority to say charges go away, not before then. There is not in criminal legal practice in the state of Georgia a motion to dismiss. You can file it, but that doesn't, there's no such remedy in Georgia for criminal cases. Okay? But you and Ms. Cabrera can talk about it. And more importantly, if you find that motion, you can have Ms. Cabrera file it for you. It's not in the docket right now. That's what that will show you. That doesn't mean you didn't try to file it, or the pre-indictment one could be lurking out there. It should be on there because pre-indictment filings are on that list. But I am not the clerk's office. And so when you say it was filed, I trust you that it was filed. But I do want to manage your expectations. If you're thinking, hey, I know I'm not going to need to go to trial because I filed that motion to dismiss and it's a good one and the judge is going to grant it. There's no bad motion to dismiss. There's no good motion to dismiss. There's no such thing as a motion to dismiss in criminal cases. But you're not a lawyer and I wouldn't expect you to know that. You've told me that Ms. Cabrera is going to be your lawyer. Mr. Abate asked us, he needs to know who to call to say, all right, we're getting ready for trial. Here's what's going on. And he should call Ms. Cabrera. That's what I'm hearing you say, Ms. Taylor. Is that correct? Okay, great. Ms. Cabrera, anything else?
Nothing further.
Appreciate your time.
Thank you, Judge. I think that's all I have.
It is. Nice to see you in person.
Yes, good to be seen.
If we don't see you, good luck with whatever's going on before July 2.
And I'll be fine. They just want to make sure that I have enough time to be okay.
Yep.
And so I'll do it right before, at the beginning of that week, so that by the time I come back to go to trial, I'm good to go.
Good.
Yep.
Sounds good.
He's telling me what.
Oh, well, go ahead, do whatever he said. All right.
I'll send
Who's this?
the one.
Oh, Senor Gallo. Buenos dias.
Judge,
You look familiar. It's been a minute.
how do you excuse?
Yes, sir. Thank you, Mr. White Collar. Mr. Gallo, I needed to give you an update.
Okay.
I have not ruled on the motion that Ms. Rios argued yet. I need to do my work. I haven't yet. So we're going to continue your trial one time, only once. So it was supposed to be in early July. Now it will move to the August calendar. I will get that order soon. If it is a good order for you, the state's going to have some trouble because they can't get in what was in the trunk. If it is a bad order for you, then you and Ms. Rios may talk about ways to work the case out. We'll see. But I just spoke with Mr. Romero and told him the same thing, that we have to move it 1 month because I haven't done my order yet. Okay.
All right.
I'm sorry that I've taken long on this, I've had some other things going on.
It's all right.
Okay, any questions?
No, I'm good.
Okay, then we'll see you again soon to have the conversation we were gonna have today, which was, here's the state's final offer. Do you want to take it or do you want to go to trial? You don't need to worry about that yet. Their offer might change if the motion goes well for you, and if the motion goes well for the state, your thoughts about what is a good offer might change, okay?
All right.
All right, thank you.
Thank you.
Thanks, Ms. Rios. All right, well, if we go in order, Mr. Thomas is next, and I think, oh, no, you're gonna bring someone out?
Oh, I'm ready on position 10, Keon Wright.
Okay,
I think that might be Ms. Clark's only case. I was just trying to get her off the team.
okay, let's do that. She seemed happy with that. Give me 1 second.
This is for you.
All right, Ms. Clark, good morning. You ready?
Yes, Your Honor, I'm ready.
Great. Let me get you on the spotlight there. This is 24 SC 000981, State versus Wright. Mr. Wright is in court with his lawyer, Ms. Wood. Ms. Wood, is it your sense that you've got all the discovery in this case?
Judge, I think I have everything but some GBI.
Results?
Yes, but otherwise I think we've got everything.
All right. Ms. Clark, is there anything in the queue over at the GBI in this case?
Yes, Your Honor, there is lab results that we're waiting on.
Okay, and are these buccal swabs from Mr. Wright, or are they lab results from a rape kit, or what is it?
They're buccal swabs from Mr. Wright, and then also there were some swabs that weren't originally tested from the sexual assault kit, and those are being tested too.
Okay. Are they in the standard queue? Is there any kind of ETA that you've got for them?
Your Honor, I was told 90 days, but that was back in May.
Okay. So that we've already chewed up 30, 45 of those days.
Mm-hmm.
All right. Ms. Wood, were you going to add something, or you just were doing the math? All right. You lean in to do your math.
Yes.
Okay. All right. Let me see. Mr. Wright's case is on the August calendar, so there may be enough time. We may have to bump it, but he's in custody, so I'm reluctant to say let's move it to September. But I know the state's going to want to have those results, and I don't know the nature of these allegations where for the DNA is the end of the road, or it's unremarkable because no one's contesting that the encounter occurred. But it seems like we should defer the final plea then as well.
Yes.
Okay. Ms. Clark, do you agree that having the final plea right now doesn't make a ton of sense because we don't have the results of the DNA?
I agree, Your Honor.
Okay. All right. I think what I'm going to do for now is keep Mr. Wright on the August calendar and preserve his final plea rights. And so all that means, Mr. Wright, what we were going to do today is I was going to ask Ms. Clark, what's the best offer for Mr. Wright? She's going to say whatever it is. And you let me know if that's something you're interested in pursuing or not. Your situation is a little complicated because unless the state's going to reduce count one, the minimum is 25 years to serve. Ms. Clark wouldn't offer you anything less, and not a lot of folks say, I'll take 25 years to serve. And so a final plea conversation is a little different than if the only thing you were charged with was the false imprisonment. There's room to move in there, and the state might say 2 years to serve, and Ms. Wood might say 1 year, and he's already done 1 year, so it's a time served sentence. But when you're dealing with rape, the numbers start at 25 and go up. That being said, depending on what the DNA results are, 25 might seem like a okay sentence because life is also a sentence someone can get for rape. But you're not going to need to navigate that tricky situation quite yet. We'll preserve your final plea right, which is your ability to try out a plea. And if you don't like the way it went, you can back out of it. You'll still be able to do that until we can have a conversation after the DNA results are back. Does that make sense?
Yes, it does.
Any questions about that process?
Not right now, no.
Okay, then I'll let you go today. We'll see you at the latest when we call that calendar in August. And if still the DNA is not ready, then we may need to talk about other things. It's not your fault that the DNA is not ready. So we'll see. But my hope is that the crime lab can get us some answers by then. Ms. Wood, anything else on behalf of Mr. Wright?
Yes, Judge. Both of his parents are here in support. They had asked me, and I didn't realize this, we had a bond hearing. I can't remember when it was,
March
but
20th.
okay, so a few months ago. Would the court consider modifying that so that it's not solely through the 10% program? So that it could be either through a bonding company or a property bond?
Maybe. Let me look it up. I don't have an issue on the financial side. I usually do 10% because people can get their money back, and it's a significant amount. It's the pretrial supervision piece that makes it more concerning. But I need to look at it may not have been one where supervision was so much the issue as it was something else. So let me look at the bond order. Okay, it is a big number, and it is 10% program with pretrial supervision. And so what we would need to do, I think, but let's ask, we have a pretrial supervision person on the call. Ms. Washington, I have a policy question for you, and if you don't know the answer, you can steer me towards the right person. If I set a bond and for one count, it's $50,000, sheriff's 10% program, pretrial supervision, and then the next count is $50,000, but you can use a bonding company. So it's, I think, called as a split bond. So half of it is through 10% program and half of it's through a bonding company. Will pretrial supervise that case or no, because there's a bonding company on part of the bond?
I will have to call and ask to see if that's something that we can do.
Okay. If you don't mind finding out the answer, that'd be great. And I'm gonna let Mr. Wright, he can go back into the holding cell, but I need to know that in general. And I need to hear from Ms. Clark before we tweak the bond. But if the dollar amount is the same and there's still pretrial supervision and an ankle monitor, I would think the state would be neutral-ish on that. I mean, they may have opposed the bond to begin with, and she may maintain that opposition, but I would be more open to that. So we'll see what Ms. Washington learns. Did you follow that, Mr. Wright?
Absolutely. I'm just wondering if you would be if that were to be modified, would I have to come back to court for that, or could I be notified through Lacey or?
You would not need to come back to court for that. I would modify the bond order. She would know that. She'd let your family know, and they'd do what they could do.
Okay.
Yes, sir.
I'm his father, Warren Wright, and the reason that I'm speaking is because I have a home, I own free and clear. It's in Fulton County, and I wanted to use that as the property bond to be able to bail him out because he needs to see his son.
Got it. Okay. And so that's another permutation would be that the bond is secured by property. And that's another thing we can think about. I just need to understand from pretrial whether they are still willing to provide the supervision that they would if it went through the sheriff's 10% program. So the answer is we're looking into it. It's not a no, it's a maybe. I need to understand how it would work. Okay. You're welcome. Anything else, Ms. Wood?
No, Your Honor, thank you.
Ms. Clark, anything else?
No, Your Honor, other than if they're gonna do the supervision, the state wouldn't have a problem.
Okay, well, we'll get that answer from pretrial, and I'll let everyone know before I do anything because people may change their mind and say, no, I have an issue with that or I don't. And if we're going to go partly 10% and then partly property bond, I need to learn more about Mr. Wright's property. If it's $1 million piece of land, that secures a lot. If it's a $5 piece of land, that secures less. And we don't need to talk about it right now. The time will come to talk about that. Okay.
Thank you.
All right. Thank you.
Your Honor, that concludes my business before the court. May I be excused?
Yes, ma'am. Thanks for being here.
Thank you.
Okay. We've got Mr. Thomas, which I think is going to, oh, Ms. Rios is gone. Mr. Deloach, what are we doing with Mr. Deloach?
Can you speak with him once more, Judge? I think we might be able to work this out today.
Okay. Why don't we, before you go speak with him, work on Mr. Bell's situation? Officer Evans, good morning. You with us?
Yes, Your Honor. Good morning.
Great to see you 2 days in a row. This is phenomenal.
Well, let me tell you this. I will be starting July 1st. I will be your assigned probation officer.
What? Seriously?
Yeah. Yep. I just found out yesterday.
Hey, I won the lottery. That's fantastic. Will you also still do accountability court?
Yes, Your Honor.
Ooh, busy. All right. Well, I come first and then accountability court.
Correct.
How will that work if I've got court on a Wednesday and Judge Krause is doing drug court on a Wednesday?
We'll just have to work it out. We'll just have to work it out. I'll be in communication, and somebody may be filling in for me on that particular day.
Do you also
that they run into each other like that?
Yep. Do you also do BHTC?
No, Sasha Jones does. She's a court specialist. She does BHTC. But I will also be rotating throughout our courts that still need rotating.
Got it. Okay. Well, the good news is the accountability court judges all work well together. So there may be times when you've got to support Judge Krause, and as long as we've got coverage, that's great. But if you are our normal go-to person, I'm excited about that. But that's great.
I'm excited to be here, Your Honor. I've done. I was actually at one time Judge Krause's court officer and doing drug court, so I'm kind of familiar of how I need to work it out in order to get that coverage for those particular days. But as they come, we'll handle it as it happens.
Okay, got it. I have here in court a very persistent gentleman named Levias Bell, and he was sentenced 1,000,000 years ago. Was it by Judge Downs?
Yes, sir.
Originally Judge Downs. Judge LaGrue was involved at some point, but I'm not exactly sure why it ended up with me. I'm happy to now be involved with it, and I signed an order that on May 30th, so not long ago at all, that said Mr. Bell has violated his probation because he missed a meeting back in December of last year, a couple other things. And I revoked 60 days and then said his probation should be terminated. And Mr. Bell is done with his revocation. He's sitting here in court. But he says that probation is telling him he is still on probation. So he is justifiably frustrated. The probation process has been complicated for him and it should be done. And so I'm wondering what we need to do so that DCS can look in its system and say, you're right, Mr. Bell, our relationship is over. You don't need to report. You don't have a probation officer. You are free and clear. And that's that.
Your Honor, from my my end, I'm showing that Mr. Bell's case is closed and there's no longer any active probation on Mr. Bell's case. Is he,
Hold
was
on.
he,
No, you keep going. Mr. Bell sometimes jumps out of his socks. So just stay seated. I promise I'll hear from you, okay? So keep going, Officer Evans.
I'm showing that his case closed May 27th, 2024. Well, I guess once they added in the revocation order. However, but it appears that he's no longer on active probation now. It could be, I don't know if he has possibly misdemeanor probation on another case.
I think
But
what
I think
happened
he doesn't
is
have active felony probation, and I've been in communication with Miss Nelson, and that's all we have. I don't have him on probation. I don't know who he could have been in contact with from our department, but I don't see that he's actively being supervised.
good. That's the reassurance I wanted. His case got put on a non-complex revocation calendar for tomorrow. They're Friday calendars that they do for technical violations and this and that. And so he got notice to go to court, and that was flabbergasting to him because he shouldn't have to go to court anymore on this case. My understanding now is that there are litigation managers from non-complex who are working to get it pulled off. But it doesn't sound like DCS has anything more to do, because if I were to ask any DCS officer if she hit the system with Mr. Bell and his case number, it would say closed, not on probation. Is that correct?
Yes, Your Honor.
Okay, great. Thank you. So, Mr. Bell, I think you should stay here. Don't leave, because I'm going to learn once the non-complex folks have said he's off that calendar.
Okay, that's ain't probation lady named Miss Hunt. It's the lady, black lady named Mr. Hunt, and he come to my house.
When did he come to your house?
She came the day I got locked up. My cousin told me. She
Yeah.
got her report at 18. He told her I'm locked up. She said I need to report the time I get out.
Okay. No one from probation's going to come to your house anymore. Okay. We just need to get you off tomorrow's calendar. All right.
Thank you, Judge.
You bet, Ms. Wood. Do you want to go speak with Mr. Deloach?
Yes.
All right. Ms. Rios, are you ready? It sounds like you've got a plea with Mr. Thomas.
Yes, there's one thing he wanted me to ask. I'm trying to get in touch with Mr.
Who's handling the plea for the state?
Is he Julian Jordan? He's on Zoom right now. Whether it's connected.
He's not. He was allegedly coming over here, but that was a long time ago.
Is it before you that he has a hearing at 11?
Yes.
Okay, then he is coming in person. He's en route as of 15 minutes ago.
Was he en route from East Point?
I don't know.
Okay.
I'm just.
Send him a text saying, hurry up.
But if it's just.
Oh, but he wasn't going to be here for this calendar. He was helping out for Willingham. Okay.
If it's negotiated, I can handle it. I just didn't want to handle it while it was non.
Ms. Rios is making there are wrinkles sounds.
I am sorry. So it was negotiated. There's a slight change that he wants me to throw in. And so I know that changes the negotiation. So I don't think that we can do it's a slight change.
Okay, well, maybe you need to talk with Mr. Jordan, because this is the day for Mr. Thomas to be able to withdraw his plea if he doesn't like it after today.
Yeah, we're doing the plea today.
Okay, it's just, what are the terms?
Yeah, it's just that I want to see if Mr. Jordan will agree to that. And if he won't agree to it, it's going to be not.
That's just non-negotiated. Okay, then we'll hold off until Mr. Jordan gets here. And the motions hearing is going to be real short, if it can even happen. The defense attorney wasn't well, and so there was a notice that we might have to cancel it. So we'll take care of Mr. Thomas. Hopefully we'll take a plea with Mr. Deloach. My litigation manager, Mr. Bell, will let me know when she hears from her colleague that you're off tomorrow's calendar. But you heard Officer Evans, probation is in their system. No probation officer is going to be knocking on your door anymore. It's just this court date you got, but that court date was set back when they thought you had missed something and you don't have probation anymore. So we're just trying to get you pulled off that calendar.
But I can get my job back. He told me if I be down by 12 o'clock, he'll rehire.
Oh, so go.
You tell me to stay.
Well, I didn't, but you didn't tell me you get your job back. Go, I'm telling you to go. If we have a phone number for you?
Four.
No, I don't, well, you have a phone on you?
Yes.
Okay, what's that phone number?
404
Yeah.
808 5714.
5714, 404 808 5714.
Yes.
Okay, hold on. I just got an email. So you may be able to leave with happy news. Yes, you should go. You do not need to report tomorrow. When your name is called tomorrow, someone from court administration will say that your case has been resolved. Okay?
Okay.
Go get your job back.
So I get locked back up, I'll come back to you.
You will, and I will straighten it out, but you're not gonna get, if you get locked back up because you break into someone's car, that's on you, all right? But you're not missing court.
Come back to my house, lock me up.
Then come see me. Yep. No more probation, and you don't need to go to court tomorrow, okay?
They locked me back up, you gonna put them in jail, stuff me?
Yep.
I'll put this attorney in jail, cause she wanna sign a warrant.
All right. Get out of here while you can. Are you Mr. Thomas? Denzel Thomas. Okay. Mr. Harvey's going to be appearing virtually. So you should stay. And I think we're still going to have a conversation about the motions. But he is well enough to do a virtual appearance, but he didn't think it was a wise idea to come into court and sit next to you, if that makes sense. I forgot we had two Thomases sitting right there, but okay.
Your Honor,
Yes.
We will be able to supervise, from my understanding.
Okay, so a split, as long as there is a part of the bond that is either UJR, that wouldn't apply here, or through sheriff's 10% program, then you can supervise.
Yes, we'll be able to supervise through the 10% program.
Okay, fantastic. Thank you.
You're welcome.
Hello, Mr. Jordan.
Hey, Judge McBurney, how are you doing?
Ms. Rios needs to talk to you.
Okay. Yeah.
Your Honor, we're ready for the plea. I just have it's not going to be negotiated. It's a small deviation. Should I email and let you know what that changed or what I'm asking for? Okay.
You can just put it on the record. It's not required to be fully negotiated. But let me make sure Mr. Harvey has joined the call as well. And so our calendars are bumping into each other right now. Mr. Jordan, there are actually two Thomases in here right now. You're going to take a plea on one, covering for Ms. Willingham. That's Jael Thomas, but Denzel Thomas is here. Mr. Harvey has just joined us virtually. You had shared with me just at a very, very high level that there was the possibility that today might be a plea or a non-negotiated plea, or it would be a motions hearing, but maybe a truncated one because one of the motions might be moot. And we'll get all that on the record in a moment. I just want to get a sense of which way we were heading with the Denzel Thomas case.
Your Honor, because Mr. Harvey did become ill after we spoke, I believe that was Tuesday. After we spoke on Tuesday, I hadn't heard back from Mr. Harvey in regards to whether we were going to proceed forward with the non-negotiated plea. The state does have one witness that's en route, Investigator Lowe. I had also emailed Mr. Harvey in regards to whether we could just proceed forward on an oral argument so that I could release Investigator Lowe. But the short answer, Your Honor, is that I'm unaware of where we're going this morning with Mr. Thomas's case.
Okay. Mr. Harvey, I think you're on the call. I appreciate you making an effort to join us during your free window when you're not feeling well. You're not stuck in 1C, but you're under the weather. Are you able to pop on volume, audio and video? Not at this point. Yes.
There.
Excellent.
Can you hear me?
Yes, sir.
Okay. I had thought, Judge, that we had talked, we had a meeting. The state was going to see if they could give me an offer that was different. And this was like, when was it, Julian? On Tuesday?
Correct.
Okay. So all of this has happened in a fairly short time span. The state, I believe, did come back, although I don't know whether it's been formalized, Julian, that they were going to make an offer that was different than the offer that has been on the table now for a while. I have not had an opportunity to talk with Mr. Thomas about that, but I kind of wanted to pre-try this case with Your Honor, because I think there's a reasonable likelihood we can resolve it. Is that something that we could possibly do?
So we can talk a little bit about the case. I'm also happy getting you, well, you wouldn't need to be in a breakout room. Mr. Thomas, you have a phone with you? Okay, you and Mr. Thomas could speak. He's here, and so you could drop off and have a conversation with him, just so that he knows what you now know about the state's offer, except you said you weren't sure how formal it was, and I don't want you to invest any time talking with Mr. Thomas about something that Mr. Jordan said, well, I didn't really mean that. So
I don't think he'll do that. I think we had a very productive meeting on Tuesday. I think that the offer has been transmitted in an informal way.
Got it.
Not necessarily an informal offer.
Got it.
If you got the difference.
I do. I understand that. Do you want to spend a little, I have another plea I could take right now while you and your Mr. Thomas, it's another Mr. Thomas in here, your Mr. Thomas could talk a little bit, and then maybe it would be appropriate for everyone to talk about where the case is going.
Okay.
All right. Denzel Thomas, do you have a good phone number for Mr. Harvey? What are the last 4 digits? Should he call the 7326 number, Mr. Harvey?
7326, that's his number.
Oh, no, I don't want you to call yourself, Mr. Thomas. If you were going to call Mr. Harvey, what are the last 4 digits of the number you'd call?
He can call me on 4628.
4628. Is that a number you've got? He's looking you up. You're not on his X feed.
Yeah, well, I don't think I'm on anybody's X feed except for my wife's.
Someone your age should be better with phones. Have you found the number yet? Does it end in 4628? Great. All right. So Mr. Harvey, you can, if it's a different number, you can just mute here. If it's the same number, you can drop off. You're probably on a computer. So just why don't you mute here? Mr. Thomas will give you a call. I'll take the other Thomas plea. When we're done with that, we'll circle the wagons.
And Your Honor, before Mr. Harvey goes, Mr. Harvey, I did solidify that offer on Tuesday at 1:34 p.m. So it is a firm offer.
Okay, good.
Does that make it formal also?
Yes.
Okay, excellent. Firm and formal. Mr. Thomas, you can step outside, give Mr. Harvey a call. When you guys are done talking, please come back in the courtroom. All right? Great. Ms. Rios, are you ready with Jael Thomas?
Yes.
Great. Mr. Thomas, you're going to come up to the podium. You'll stand in front of the screen. Ms. Rios will be to your right, and Mr. Jordan's going to be up here. If you don't mind adjusting that monitor so we can get you on the screen as well, Ms. Rivers can see you. Thanks. Ms. Rivers, are you ready?
Yes, I am.
Great. We're going on the record with position 4. It's 23 SC 191148, State versus Jael Thomas. Mr. Thomas is in court with his lawyer, Ms. Rios. We have Mr. Jordan for the state. And Mr. Thomas, my understanding is you're ready to go forward with the plea. Is that correct?
Yes, sir.
And it's largely negotiated. It sounds like a whole bunch of the terms that I'm going to hear from Mr. Jordan, you and your lawyer agree with, but there may be one little piece where there's a disagreement, and I'll hear what that piece is. Do you understand that it may not be exactly one-to-one agreement on the plea?
Yes, sir.
Today, because it's your final plea date, you have the ability to withdraw your plea, step back from the agreement if the sentence I give you is more severe than what your lawyer asked for. I'm not bound by your agreement. I don't know what it is, but I'm going to make it up. Let's say it's 2 years probation. I might learn something about you and about this case and say, I think it needs to be 5 years probation. If my sentence is more severe in that way, you can say, nope, I'd rather go to trial. And it's like this never happened. But you'll be given a chance to talk to Ms. Rios about it. It may be that, and again, I'm making it up, the recommendation is that you have 40 hours of community service. And I look at it and think about it and say, it should be 80 hours community service. That is technically a more severe sentence. And so you could say, no, thank you. But Ms. Rios might say, just do the extra 40 hours. I mean, she's going to give you her wisdom. You'll decide in the end. You'll get a chance to speak with Ms. Rios about whether you want to go forward or not, if I do anything other than say exactly what Ms. Rios asked for. Okay?
Yes, sir.
All right, Mr. Jordan.
Thank you, Your Honor. Mr. Thomas, can you please raise your right hand? Do you swear or affirm that the testimony you're about to give before the court in this matter is the truth, the whole truth, and nothing but the truth?
Yes, sir.
Thank you. You may place your hand down. Can you please state your true, correct, and legal name for the court, please?
Jael Thomas.
Thank you. Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there any medication that you normally take that you have not been given today?
No, sir.
How old are you, and what is the highest level of education that you've completed?
I'm 43, and the 10th grade is the highest level.
Are you able to read, write, and understand the English language?
Yes, sir.
Do you understand that you have been charged with 1 count of aggravated battery?
Yes, sir.
Do you understand that you have the right to plead either guilty or not guilty to this charge? And if you pled not guilty or remain silent, you would receive a jury trial.
Yes, sir.
Have you had enough time to speak with your attorney, Ms. Rios, about all of the facts and circumstances known to you regarding the sole charge in this indictment, including any potential defenses?
Yes, sir.
Ms. Rios, are you satisfied that your client has a full understanding of this proceeding?
Yes.
And Ms. Rios, do you waive formal reading of the indictment?
Yes.
Do you also waive any and all defects in the indictment, including any with respect to your client's name?
I'm unaware of any defects, but I do waive for the purposes of the plea.
Thank you. Mr. Thomas, do you recall originally having been arrested on this sole charge in this indictment?
Yes.
Do you understand that you are entering a guilty plea under North Carolina v. Alford to the offense of aggravated battery?
Yes, sir.
Do you understand that the minimum for that offense is 1 year and the maximum is 20 years?
Yes, sir.
And did your attorney previously advise to you that same minimum and maximum sentence range for that charge?
Yes, sir.
Do you understand, Mr. Thomas, that this is a non-negotiated plea and the state will recommend a sentence to the court? Your Honor, the state's recommendation in this case is 3 years to serve 8 months. That is time that Mr. Thomas has already served and completed, the balance being probated. The only special condition of probation, Your Honor, would be no violent contact with the victim listed in this indictment. The state, Ms. Willingham, did not include any other special conditions. So that is the state's recommendation.
Okay.
Mr. Thomas, are you aware that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum on this charge?
Yes, sir.
All right. And did you discuss the state's most recent offer with your attorney?
Yes.
Mr. Thomas, do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, sir.
Do you understand that this is a guilty plea, which is permanently recorded on your criminal history?
Yes, sir.
Do you understand that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes, sir.
Mr. Thomas, are you currently on probation or parole?
No, sir.
Are you a United States citizen?
Yes, sir.
Mr. Thomas, do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, sir.
Do you understand that your guilty plea may affect your right to vote, your right to hold public office, your right to serve on a jury, your right to obtain a passport, your right to receive, possess, or transport a firearm, and your ability to obtain employment?
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm during the commission of a crime, you will be guilty of a felony, which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you, and the right to testify or to remain silent and not incriminate yourself?
Yes.
Do you understand, Mr. Thomas, that by pleading guilty, you were giving up the following rights, which I will now list off: the right to a trial by jury, the right to remain silent and not incriminate yourself, the right to confront witnesses called to testify against you, the right to the assistance of counsel hired by you or to court-appointed counsel if you could not afford an attorney at a trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt, and finally, the right to appeal if convicted of these charges after a trial.
Yes, sir.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Are you pleading guilty under North Carolina v. Alford because you have decided that it is in your best interest to do so?
Yes.
Are you aware that even if you do not admit guilt, this is a plea of guilty and places you in the same position as if you were convicted by a jury at a trial?
Yes.
Mr. Thomas, how do you plead to the sole count of aggravated battery in, my apologies, Your Honor, indictment number 23 SC 191148?
Yes.
Is this guilty plea freely and voluntarily given with the full knowledge of the sole charge against you?
Yes, sir.
Do you understand that you have 30 days in which to appeal your conviction based on your plea today?
Yes, sir.
Do you understand that since this is a felony that you're entering a plea to, you have only 4 years from today to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, sir.
And Your Honor, for a factual basis, on September 24th of 2021, an officer from the Atlanta Police Department responded to 479 Joseph E. Boone Boulevard in reference to a previous call where the caller relocated to that location. Upon arrival, the victim in this case, Miss Brianna Brown, and that may be pronounced Brianna, I apologize if I misstated that. Brianna is spelled Breana. Last name Brown has normal spelling. Miss Brown was being checked out by Atlanta Fire Engine 1. The officer who responded could tell that her right arm was disfigured. He could tell that the right arm was possibly broken because her elbow and her forearm was bent upwards, where her wrist was resting on her ear. The officer asked Miss Brown about how her arm became broken. She stated that it occurred during a physical dispute involving her child's father, the defendant, Mr. Jael Thomas. She stated that a physical dispute became violent, which resulted in her injury. Your Honor, I believe that medical records later did confirm that she sustained a serious injury to her arm. Your Honor, at that time, she did make a positive ID on Mr. Thomas. Mr. Thomas was later arrested for the offense of aggravated battery. Your Honor, in regards to the state's proposed resolution, from my understanding, Ms. Willingham has talked to Ms. Brown. Ms. Brown has never been keen on prosecution in this case. She does want help. From my understanding, the child that they share does suffer from some autoimmune deficiencies, and I apologize, Mr. Thomas, if I stated that incorrectly. She just wants help with the child, so we do believe that this is a fair negotiated resolution.
Okay. And are you aware of any restitution that's involved in terms of medical treatment that Ms. Brown required?
None that the state is aware of or has ever been requested, Your Honor.
Okay. All right. Ms. Washington, can you share with me the criminal history information you have for Jael Thomas?
Yeah, sure, Honor. There are 28 arrest cycles, a 2001 felony conviction for purchase, possession or sale of marijuana and manufacturing or sale of drugs, a 2005 misdemeanor conviction for 2 counts of simple battery, a 2009 felony conviction for purchase, possession or sale of marijuana, a 2009 misdemeanor conviction for simple battery, family violence, a 2011 felony conviction for possession of marijuana, and a 2014 felony conviction for battery, family violence. Nothing further.
Thank you. And Officer Evans, is Mr. Thomas currently on probation for anything?
No, Your Honor.
All right. Ms. Rios.
Yes, Your Honor. Mr. Thomas is 43 years old. He's currently on disability for a defibrillator. He has a irregular heart rhythm, and he receives SSI for that. I believe I emailed you just to verify a copy to verify. He has 6 children, ages 23, 21, 18, 14, 13, and 3. The younger children, of course, he's still financially responsible, and he's only using the little money that he gets from his SSI along with his bills. So for that, I'm asking for the fees to be waived, so the money that he has can go towards his children. I have spoken with the complaining witness, and her main concern is that she wants help financially and for him to physically get the child. And given that he has not had any history in the last 10 years, we are also asking for, the only difference with the negotiated plea was that we're asking for the 3 years served 8 months, the balance is the remainder on probation, but we're asking for that probation to be suspended upon the completion of an anger management course. He hasn't been on probation for a long time, doesn't want to be on probation. And aside from this incident, he's been doing really well for the last 10 years and just focusing on his health and taking care of his children. He also lives with his aunt at this time in Atlanta. So we just ask that you accept the plea with the change of it being, the probation being suspended after the completion of the anger management.
Okay. All right. There was a bench warrant in this case, and Mr. Thomas spent another month in jail because of that. You may not have been involved with the case at that time. And I know this has not ever been Mr. Jordan's case. What were the circumstances around that?
They did when you lift the bench warrant, I still stayed in here. I guess the assistant didn't even put in for me the bench warrant to be lifted, so I did an extra week in here. I didn't even get out that remaining Friday when you told me.
Okay, I'm not worried about that. I'm sorry about that. I didn't mean for you to do any extra days.
Like
my question was,
months.
Why did you get it was 44 days. Why did you have a bench warrant at all?
Oh, because my mom had passed last year and they sent it to the wrong address. Once we removed all her things from that address, we did a change of address for the post office, but we didn't know that.
Got it.
I supposed to did one here at the court.
Okay, so they didn't send it to the wrong address. They sent it to the address of record. You thought you had cleared that up by changing the address through postal service, but you didn't change it here.
No, sir.
Okay, got it. Do you have any questions about anything we've been talking about?
No, sir.
You have how many kids with Ms. Brown?
Just one, sir.
The youngest, the 3-year-old?
Yes.
Okay. When's the last time you saw Ms. Brown?
It's been a while.
Is it a condition of your bond that you can't be around her? The child you have with her, boy or girl?
A boy.
Name?
Keontae Thomas.
Keontae. Are you able to see him, or because you can't be around Ms. Brown, you haven't seen Keontae?
Well, my niece we was doing it through a third party. She would take him over my niece's house, and my niece would call once she drop him off, and I'd be able to go to my niece's house and see him then.
Good. Is that still happening, or that hasn't happened for a while?
No, it haven't happened since I've been out.
Since you got out the second time?
Yes.
Okay. All right. Why is that?
I mean, she been saying she been working and he was in the hospital. I've been to the hospital and seen him. But as in that condition as her dropping him off over my niece's house, no.
Okay. Keontae's been in the hospital.
Yes.
Because.
Yeah, sickle cells and he suffers from autism.
Okay. All right. And you have a defibrillator?
Yes, sir.
Okay. So I have a relative who has one, but that person works. Tell me why you can't work.
Well, there was a sign that I went to court and they did the health thing with the physical with Social Security, and they determined that situation.
Okay. They said that you are not able to do any job.
Yes, sir.
Okay. Got it. Well, Mr. Thomas, I find there's a factual basis for your plea. Understand it's an offered plea, which means you've decided after talking with Ms. Rios and thinking about it that it's in your best interest to enter this plea, but that you disagree with some or all of the facts that the state says they could prove at trial. But what I'm finding is that if the things the state said were presented to the jury, they could believe that. And if they did believe it, the jury could find you guilty. So I'm accepting your plea. I also find your plea is knowing and voluntary. You know what those words mean, but no one's forcing you into this plea and you've understood all the things we've discussed. Is that correct?
Yes, sir.
I'm sentencing you pursuant to the Probation Options Management Act. And all that means is that while you're on probation, if you have a minor issue, maybe you miss a meeting with a probation officer, you don't have to come back and see me about that. You'll work that out with probation. But if it's more serious, you get arrested for anything, that comes back to me and we'll sort that one out. Ms. Rios, can someone in my office sign the indictment on your behalf?
Yes, Your Honor.
Mr. Jordan?
Yes, Your Honor.
Mr. Thomas, is it okay if we electronically put your name on the indictment indicating your plea?
Yes.
Great. So I'm gonna give you two options on this. I am fine with the sentence as the state has recommended. I'm actually gonna make it 7 months to serve, not 8, because you did just less than 8 months. You did 220 days across your 2 times you were in. So it's a sentence of 3 years to serve 7 months, credit for time served, balance probated. So that means you're gonna be on probation for 2 years and 5 months. Special condition of probation number 1, no violent contact with Ms. Brown. So as of today, you can now call her to say, could I see Keontae? And that's not a violation. She can't say, oh, you violated your bond or anything like that. You don't have to reach out to her, but it's okay if you do. In fact, you could knock on her door and say, I'm here to pick up Keontae. Obviously, if she tells you to go away, you need to honor her word, but that has nothing to do with this case. That would just be how you interact with people. I will also add the special condition that you complete the Family Violence Intervention Program. That is more involved in anger management. It's not one class. It's a series of classes. So it would take you a few months to finish that. But if you do accept that version of the sentence, then I will have your probation suspended after you show probation that you completed the Family Violence Intervention Program. If you don't want to mess with that class, then it's 2 years and 5 months of probation, and you do every one of those months of probation. I'm going to waive your supervision fees regardless because you are on disability. So it's not a money thing. It's, do you want to do the Family Violence Intervention Program and probation ends right after that, or you're done with going to classes and you'll do the full 2 years and 5 months. I'm gonna have you talk with Ms. Rios about it because you may be saying, what's this FVIP? And Ms. Rios can tell you a little bit about it. And then you let me know which one, and that'll be your final sentence. Okay?
He would like your first option with the course.
The straight probation. Oh, with the course.
Yes, with the course.
Got it. Okay. So we're clear. Your sentence as to the only count is 3 years to serve 7 months, balance probated. Special condition number 1, no violent contact with Ms. Brown. Special condition number 2, complete a family violence intervention program. Upon completion, you got written proof that you completed FVIP, then your probation will be suspended. Okay?
Okay.
All right. You need to sit tight because Officer Evans is going to give you probation reporting instructions. Ms. Rios will write them down, but she's going to let you know where you need to go and when. Mr. Jordan, anything else before we do that?
Nothing further from the state. No.
All right, Officer Evans.
Thank you, Your Honor. Mr. Thomas, what is your current address?
2900 Laurel Ridge Way.
Can you spell that, Laura?
Laurel.
Okay. And that's Fulton County?
Yes, that's Fulton. That's East Point.
Okay. You're going to report to 276 Memorial Drive. That's Southwest Atlanta, 30303 on July 10th, 2024 at 10 a.m. Failure to do so may result in a warrant for your arrest. Do you understand?
Yes.
Were you able to receive that information?
Yes.
Good luck to you. Thank you.
All right. Anything else, Ms. Rios?
No, thank you.
Oh, I'm sorry, Your Honor. One more thing. May I have a good contact number for you, Mr. Thomas?
470-343-8761.
I apologize, Your Honor. Thank you.
No problem. Great. Thank you. All right, do you know what's happening with Mr. Harvey? Because you haven't moved.
No, Your Honor.
Why don't you stay right there, just in case?
Okay.
You're good to go. Other Mr. Thomas, why don't you come on up to the podium and we're gonna figure out what we're gonna do. All right, Mr. Harvey, if you could unmute, let's get an update from you as to what the plan is for the rest of this morning.
Judge, I think I had a brief opportunity, and thank you for that, to talk with Mr. Thomas about the offer that's now on the table. I think that we can affirmatively plan that offer would be accepted, but I just need a little bit more time to talk to Mr. Thomas. Talking to him in a chat or a phone call while we're here in court, it's just not the same as having the opportunity to meet with him and to go over everything. But I anticipate that offer will be accepted. So however you want to proceed, I don't see any reason to proceed forward with the motion hearing at this particular time. There are a number of motions. Some of the motions are moot because the state has indicated to me that they will not be using anything gathered from some of the seizures. So that's my suggestion. I guess, well, can we put it on another final plea calendar?
Yes, I think that makes the most sense, with the caveat being your peculiar schedule. You're either in 1C or the Virgin Islands, and I don't want to defer this case for another bunch of weeks or months. We actually have on the call the mother of the deceased in this case, and I'm sure she's anxious for this to move forward as well. So I don't know. Hold on one second. You didn't mute that. Mr. Harvey, I don't know how much notice you get from Judge Glanville as to when there will be a down day. We rarely hear from him. And so we're not able to, we're sort of reacting on the spot that, oh, tomorrow so-and-so will be free. I would very much like to get a date certain that would work for you. I'm pretty confident I can grab Mr. Jordan when we can get you on a calendar. Do you have any insight as to when there'll be another, and it doesn't need to be a whole day. If you know it's a half day in 1C, then we'll get you in for the afternoon. And it's not like a plea hearing is all that long anyway.
Well, I think we'll have a number of witnesses, but be that as it may, the answer to that is, I don't know. For example, Judge Glanville had told us for weeks and weeks that we were going to be off yesterday, today, and tomorrow. And then we came in and we finished a session on Tuesday and he said, okay, be here tomorrow. So it's a little bit mercurial with regard to days, even days that he has said are going to be administrative days. My suggestion is this: I don't know whether you have a regular final plea calendar, but if I'm downstairs and I can get someone to sit in, I can come upstairs and we can resolve this.
Okay. Why don't we do that? I'll get with Ms. Nelson. And is there a day of the week, as you understand the flow insofar as there is a flow with that trial, that is more likely that either one, you won't be in session, or two, if you are in session, you being out of there for an hour, however long our hearing would be, is less disruptive to your client?
Judge, no. There are some Friday mornings where Judge Glanville, I believe, does Veterans Court, and we don't appear until like 1 o'clock on a Friday. But that's not every Friday. And I don't know when that is going to occur. I generally have people that can cover for me. So if you just set it on your regular final plea calendar, I will try to make arrangements to have somebody cover downstairs, and I can come up and join you. And if that's not going to happen, although I think that's a remote possibility, then of course we'll let you know.
How much time should we bake in for this? You mentioned calling witnesses. So it wouldn't be a 20-minute affair. Is this we need all morning, or what are you envisioning?
Well, this event happened back in 2020. It was not indicted till 2022. And in the meantime, Mr. Thomas has been consistently employed. I have a number of folks from his current employment, from his past employment. For example, he worked at UPS for 5 years. So I don't think it'll be longer than an hour and 15 minutes. But you know me.
I do, so we'll bake in 2 hours.
Okay.
All right. Let me check one thing. There was a co-defendant at one point.
Yes,
How does that work?
that was the victim's mother, Ms. Kelly, who's on the call right now currently. That was declined, I believe, June 3rd of last year.
Okay. Got it. Okay. So Mr. Thomas, we're gonna get another date. You will need to be here in person for that date. Mr. Harvey will be here in person for that date. And it sounds like although no one is ironclad committed to it. It sounds like what we'll do when I see you next is go forward with a plea. The state will, you actually just heard part of a plea. They'll do what they do. Mr. Harvey will be presenting some things on your behalf. And then I'll decide if, one, I'm going to accept the plea, and then if it's a joint recommendation, if I'm going to accept the joint recommendation. You still have what are called your final plea rights. So if the sentence I impose on that later date is something more severe than what Mr. Harvey asked for, you can always back out of it, withdraw your plea, and then we'll move forward with things. But it sounds like a lot of thought has been put into this by the prosecution and by Mr. Harvey, and I tend to be appropriately influenced by that level of preparation and investigation. So we'll see. Mr. Harvey's going to very understandably wants to meet with you face to face to talk more about this, because a plea is a significant step forward in the case. He'll spend time with you. We'll get a new date, and I will see you then. Do you have any questions about any of that?
No question, Your Honor.
Okay. Ms. Kelly, do you have any questions about what we just discussed?
No.
Okay. How will she learn about the date? Just because victim advocate will contact her?
Yes, Your Honor. We spoke with her yesterday. We'll make sure to contact her when the date is established.
Great. And so, Ms. Kelly, you will have a right to be present as well and to be heard potentially if you want to be here. It is entirely up to you, but someone from the DA's office will be letting you know the date and time of this next hearing, okay?
Okay.
All right. Thank you. Mr. Harvey, anything else?
No, sir. Thank you for allowing me to appear by Zoom. I didn't want to give everybody a cold or whatever.
Yeah, you sound like you got some kind of ick. So thank you for keeping it in your funky loft area, and we're gonna be safe here. Okay.
Yes, sir. Thank you, Jim.
Take care.
All right. Bye-bye. I'll talk to you, Julian.
Yes, sir.
And he'll talk to you too, Mr. Thomas. All right. Where are you working now?
UNFI.
Say that again.
UNFI.
What is that?
It's like an abbreviation. United Whole Food.
Okay. What do you do?
Order select.
Got it. So it's a warehouse thing?
Mm-hmm.
All right. Well, you are free to go for now.
Okay. Thank you, Your Honor.
Take care. All right. We have Mr. Deloach.
Yes.
All right, let's do that. And I just got, was it an email or a text? Text that you guys want to handle these revocations. And we can do that. Let's just talk scheduling for a moment. I have a 1 o'clock Zoom call I have to be on. It will be 15, 20 minutes. So I'm fine as long as Ms. Rivers is going until then to see what we can get done. And then we can hop right back into things after that. And I thought, though, when you guys say, hey, we've resolved things, we've got one messy revocation situation if Mr. Adams is still on it. That was going to be is he not on it anymore? I'm talking about Randy Wright. I won't be obscure.
I'm on it now.
You're on it? Okay. I thought that was one where when the defense attorney, I thought it was Mr. Adams, it may have been you. I know the difference, but I just know there was one where Mr. Adams heard that the state was going to, he said, we stipulate. And the state said, great, it's a 5-year recommendation. And he said, can I unstipulate? I said, you can unstipulate.
I did unstipulate, but my reasoning was this was like a Zoom calendar and it's just easier when I'm sitting next to my client.
So Randy Wright is your case. Yes. Then great. I know you're not Randy Wright. We will just get as much as we can get done before 1 o'clock. Consistent after this plea, I'll see if Ms. Rivers needs a break. And then we'll just keep going till 1. If we haven't finished, then right after this Zoom call, we'll wrap up and you guys can avoid. But I think as long as you're not trying to go to Georgia Tech, the traffic's not going to be that bad. That this is more people making it a big deal. But I want to honor your traffic concerns. I got in lots of trouble on Snowmageddon. I kept people here too late. And certain people have never let me forget that, including my entire staff. So we won't do that because it was just a little bit of snow.
And Judge, just for Ms. Nelson's purposes, this is officially a non-negotiated plea, but it's negotiated all the way to the end. So we're just debating a few months.
But she's gonna check non-negotiated.
Yes.
Good.
Yes.
Just like she did with Jael Thomas.
Yes.
All right, Ms. Rivers, you good if we do one more plea and then take a census of who needs a break?
Yes, I'm ready.
Great. All right.
Your Honor, I apologize for interrupting. May I please be excused?
Thank you. So yes, Ms. Nelson will be back in touch with, here's what we're doing with Denzel Thomas.
Yes, ma'am.
Are you gonna have a bunch of witnesses or that will be Mr. Harvey's sort of mitigation witnesses?
I believe so, Your Honor. I believe Ms. Kelly will be more in favor of the sentence that Mr. Harvey is going to be asking for, so I don't want to answer.
Oh, it's a non-negotiated plea.
Yes.
Interesting. And Ms. Kelly, you think, well, okay, these things happen. All right, it'll be interesting.
Thank you, Your Honor.
All right, take care. Oh, I heard Marufo plea.
Yes. That's
Huh.
right.
All right.
We might ask Ms. Nelson as a heads up to get an earlier date, because my understanding is that Mr. Lee will not be available on the 8th, so we may ask for the 2nd or the 3rd.
If she can fit you in, then you're off 2 trial calendars.
Yes.
All right, thank you.
Thank you, Your Honor.
Take care. You're Mr. Deloach.
Yes.
Mr. Deloach, I'm Judge McBurney. We met before. You have an almost negotiated plea, not quite, little piece where there's a disagreement. Your case is 24 SC 000-607. Ms. Wood is here in court with you. Ms. Nix is the prosecutor, currently on the witness stand. She's going to put you under oath in just a moment. Once you're under oath, you need to answer all of her questions truthfully and completely. It is very important to me that you let me know if you have any questions or if at any point during this process, something's not making sense. And we'll stop and do our best to make sure that it does make sense. Will you let me know?
Yes.
Okay, and make sure when you are answering, you're welcome to nod or shake your head, but there got to be verbal answers because the court reporter only takes down what is said.
Yes.
Okay? And make sure you speak up.
Yes.
All right, good. Ms. Nix.
Thank you, Judge. Mr. Deloach, please raise your right hand. Do you swear or affirm that any statements or testimony that you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
I do.
You can put your hand down. Please state your true, correct, and legal name.
Shine Bendelo.
Please spell your name for the court reporter.
SHAWNABRINDELOACH.
Are you at this time taking or under the influence of any medicine, drugs, or alcohol?
No.
Is there a medication that you normally take that you have not taken or been given today?
No.
How old are you?
47.
47.
How far have you gone in school?
The 11th grade.
Is English your native or dominant language?
Dominant.
You understand that you've been charged with the following offenses: counts 1 and 2, burglary in the 2nd degree, count 3, theft by taking, and count 4, criminal trespass.
Yes.
You understand that you have the right to plead either guilty or not guilty to these charges?
Yes.
You understand that if you plead not guilty or remain silent and refuse to enter any plea at all, then the state is required to prove the charges against you at a jury trial?
Yes.
Have you had the opportunity to review your rights with your attorney?
Yes.
Have you had enough time to speak with your attorney about all of the charges in this indictment against you, including the facts and circumstances relating to each charge?
Yes.
Do you need more time to discuss the case with your lawyer, Ms. Wood?
No.
Are you satisfied with her services?
Yes.
Ms. Wood, do you waive a formal reading of the indictment for purposes of the plea?
We do.
And do you waive any and all defects in the indictment for purposes of the plea?
So waived.
Mr. Deloach, do you remember having been arrested on these charges?
Say that again.
Do you remember having been arrested on these charges?
Yes.
Has your attorney advised you of the minimum and maximum sentence for each charge to which you're pleading guilty today?
Yes.
Do you understand that your plea of guilty today is called a non-negotiated plea and the state may recommend a sentence to the court without you having agreed to it in advance?
Yes.
You understand that the court can impose any sentence authorized by law, including a higher sentence than that recommended by the state, up to the maximum sentence on each charge?
Yes.
Do you understand that if the court decides to order a sentence that differs from what your attorney requests, that you have the right to withdraw your plea of guilty?
Yes.
Are you currently on probation or parole anywhere?
No.
Do You understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit?
Yes.
You understand that if you're on probation, you must follow all the special conditions of your probation?
Yes.
You understand that if you fail to follow all the special conditions of your probation, then you'll be subject to revocation of that probation for the balance of your sentence?
Yes.
You understand that you are not allowed to possess or use a firearm while on probation?
Yes.
Are you a United States citizen?
Yes.
Do you understand that by pleading guilty to a felony, you may not receive, possess, or transport a firearm?
Yes.
You understand that doing so could result in new criminal charges for which you face a sentence of up to 5 years?
Yes.
You understand that by pleading guilty to a felony, you also may not use a firearm in a crime in the future?
Yes.
You understand that if you were in the future to use a firearm during the commission of a crime, you would face a 15-year custodial sentence consecutive to the sentence for the underlying crime?
Yes.
You understand that by entering a plea of guilty today, you're waiving any and all defenses, including any mental health defenses?
Yes.
You understand that by pleading guilty, you are giving up the following rights: the right to a trial by jury, to remain silent, to confront witnesses against you, to the assistance of counsel, to the presumption of innocence, and the right to appeal if convicted of these charges at trial?
Yes.
Is it your decision to waive these rights and enter a guilty plea today?
Yes.
Has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No.
Is it your decision to enter a guilty plea because you are in fact guilty?
Yes.
How do you plead to the charges of 2 counts of burglary in the second degree, theft by taking, and criminal trespass in indictment number 24 SC 000607?
Oh, I plead guilty.
You plead guilty?
Yes.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
You understand that you have only a limited right to appeal this guilty plea conviction?
Yes.
You understand that if you wish to challenge the voluntariness of your guilty plea, you must do so by filing a habeas corpus petition. In the felonies, you have 4 years from today to do so, and in the misdemeanor, you have only 12 months from today to do so.
Yes.
I don't think I read out what the state's recommendation is.
You did not, because I haven't written it down.
The state's recommendation is a 5-year sentence that the defendant serve 6 months of that sentence, with the balance to be served on probation. That will be to both counts 1, 2, and 3. And in count 4, which is a misdemeanor, state recommends a 6-month sentence to be served all concurrently with each other. Special conditions are no contact with the any victim. In this case, it's 2 businesses, but any employee or anything of either of those businesses, and stay away from both of those businesses. That is Ballard Design Outlets, or Ballard's Design Outlet Store, I think is actually what it is. And then Elliott Roswell Apartments. And restitution in an amount to be determined. I should have that number soon.
All right.
Had this case gone to trial, the state would expect the evidence to show that on July 11th of 2023, the defendant did enter a maintenance shed, which is a building belonging to Elliott Roswell Apartments, with the intent to commit a theft therein. The defendant took a golf cart, drove it to the building of Ballard Design Outlet Store, and did enter that store. It's a furniture and decorations store outlet. He did enter that building with the intent to commit a theft therein. He entered through the roof and then cut a hole in the drywall in order to enter with the intent to commit a theft therein. He did take from Ballard Design Outlet Store 2 end tables, a safe, US currency, paintings, 2 Apple iPad tablets, all with the value greater than $500, and did so with the intent to deprive the owner, Ballard Design Outlet, of that property. He also caused damage to the office wall of Ballard Design Outlet by breaking through the wall with the value of that damage being less than $500. And that all occurred in Fulton County. The addresses for Ballard Design Outlet is 1475 Holcomb Bridge Road in Roswell, and Elliott Roswell Apartments is located at 1450 Rain Tree Way in Roswell.
Did he use the golf cart as the getaway vehicle as well?
Yes,
Like he piled these end tables and the safe all in the golf cart?
Yes, in order to get away with the items that he stole from Ballard Designs, he used the golf cart that belonged to Elliott Roswell Apartments.
Okay, and this is all on surveillance footage, which is how you're able to say what happened, like he putted in the golf cart from one place to the other?
Yes.
Okay. Anything recovered and returned?
I believe that the golf cart was returned. And I don't believe that any of the other items that were taken from Ballard Design Outlet have been recovered.
And the safe, you mentioned he took a safe. Did he take a safe that was for sale at Ballard, or he took a safe that was,
It was in the
maybe
office.
he would be hoping, full of money?
It was in the office, so I would imagine he was hoping it would be full of money.
Got it. All right, thank you.
The defendant does have 3 prior felonies, all in Florida, from the early 2010s. One is a battery, and I've not been able to confirm if that would be a felony in Georgia, but I believe that it would be just on a quick review of the different laws. Also a fraud and false statement charge, and a burglary of a business all in Palm Beach, Florida.
Got it. Okay. Ms. Washington, do you have first, how many cycles does Mr. Deloach have? And then do you have any other conviction history for him?
Yes, there are 27 arrest cycles, multi-state interaction in Georgia and Florida, as mentioned. There was a 2004 felony conviction for burglary that was also out of Florida. A 2007 misdemeanor conviction for battery, an 2006 misdemeanor conviction for trespass in Florida. And as mentioned, there was a 2012 felony conviction for battery in Florida, also a fraud conviction in 2012 out of Florida. There was a 2013 felony conviction for driving while license suspended by a habitual offender that was also out of Florida. And lastly, I think she mentioned the 2016 felony conviction for grand theft from a dwelling that was also out of Florida, but no FTAs or probation violations listed in the last 10 years on the GCIC.
All right, thank you so much. That gets us to you, Ms. Wood.
Thank you, Judge. Mr. Deloach is 47. He was most recently working at HD Supplies prior to this arrest. He has 4 children. He has a fiance who's very supportive, and I think I dropped the ball. I did not get her the information for today. So I did want to let the court know that she's very supportive of him and eager for him to get out. Judge, we're asking for a total sentence of 5 served 4 months. He's already done the 4 months. He served 28 days for the original arrest last summer, and then he did miss a court date. And so for the failure to appear and then the bond issue that we recently had, he served 95 days. So a total of 123 days. Judge, I would be requesting that probation fees be waived for the first few months, just as he gets back on his feet. And then also I would be requesting a restitution hearing for this case. Otherwise, that's all we have for this case.
Okay. Got it. Mr. Deloach, I know we've met before because we've had bond hearings, and so I learned some about your desire to get back with your family and support them. Is there anything else you want to add about this case, or anything else you think I should know before I figure out what I'm going to do?
I'm just tired.
You're tired.
I'm ready to actually continue back working, being with my family.
Okay. I can understand that. And looks like no matter how I slice it, if I go with either recommendation, you will be back with your family soon. The state is not recommending 10 years or anything like that. Okay, well, Mr. Deloach, I find there's a factual basis for your plea. I can understand why you wouldn't go to trial if a bunch of this stuff is on film. I also find that your plea is knowing and voluntary. Voluntary means no one's forcing you to do this, and knowing means that you've understood the things we've been discussing. Do you agree with both those?
Yes.
Okay. I'm sentencing you pursuant to the Probation Options Management Act, and all that means, because I don't think you've been on probation in Georgia, you may have been in Florida, is that while you're on probation here in Georgia, if you have a minor violation, you and probation will address that. I don't have to get involved, or put differently, you don't have to come see me. But if it is more significant, you get arrested, anything like that, that comes back to me. Ms. Wood, can someone in my office sign the indictment for you?
Yes, Judge.
And Ms. Nix?
Yes, sir.
Mr. Deloach, is it okay if someone electronically signs the indictment indicating your guilty plea?
Yes.
Okay, we will do that. All right, on count one, I am going to sentence you to 5 years to serve 6 months with the balance probated. Count two is the very same sentence. Count three is the very same sentence. And count four is criminal trespass. It's a misdemeanor. That'll be 6 months to serve. You will get credit for every day you've been in, and you have very little left to serve. It will be county time. You're not going to get sent down to the Department of Corrections because there's only a little bit left. Special condition of your probation, number one, is stay away from that Ballard Design outlet. That's the Holcomb Bridge address. And special condition number two is you stay away from the Elliott Roswell Apartments. That's that Raintree Way address. What that means is that stay away is that if you are caught on that property, not only is that criminal trespass, but it would be the type of violation of your probation that will come back to me. And one way you're going to show me that you're doing things differently once you get out is that you're not getting mixed up with anything like this. Go back to HD Supply or whatever other work you're able to land, and move forward in that way rather than the kind of stuff that was going on less than a year ago. Your case has moved real quickly. I will waive your probation supervision fees for the first 3 months. Because you're not going to get a job day one, but you are a resourceful person. You've made that clear to me in some of our conversations, and I bet you will get a job pretty quickly. But for those first 3 months, as you're plugging back in with your family and working to support them, don't worry about paying the supervision fees. And I will also set a behavioral incentive date of June 28th. 2027. That is 3 years from, well, you know what? I'm going to make it actually October 1st of 2027. And that'll be about 3 years after you started your probation. And if you have done everything you're supposed to do on probation, then probation's going to say, let's just close your case out. And you don't need to do the full 4.5 years. And we're going to table restitution for now. If we have a hearing and the state shows what it can show, then there'll be restitution. But for now, your sentence does not include a condition of restitution. Ms. Nix, anything else in Mr. Deloach's case?
No, sir.
All right. So I guess, Ms. Wood, you and Mr. Deloach should talk for a moment because this is his final plea. He could choose, because he did not get the sentence you recommended, to withdraw his plea. You're going to stay where you are until we can get you a trial. I'm happy to have a trial for you if that's what you want. It's very close to the sentence you asked for, but it's not the sentence that gets you out today. There's a little bit more time you're going to spend, which I think is appropriate given everything I've learned about this case and about you. But why don't you two talk for a minute? Because you may say, you know what, Judge, I'd rather go back into custody and wait for my trial. And I will certainly honor that request. Okay? All right. So we'll pause this. Okay, let's just get it on the record. So Mr. Deloach, you had an opportunity to speak with Ms. Wood? And you want to go forward with your plea? All right, I wish you the best of luck and a speedy reunion with your family.
Do we need reporting instructions?
We do. So if you'll come back to the screen, Officer Evans is going to ask you a little bit about your expected residence and give you probation reporting instructions, okay?
Mr. Deloach, when you are released, what county will you be residing in?
It would, I'm not sure at the time.
What's your current address?
My current address is, Old Dogwood Road, 999 Old Dogwood Road, Roswell.
Oh, I'm sorry, I had a different address for you. You said, what was that again?
999 Old Dogwood Road, Roswell.
Okay, so I'm showing that it's Clayton County?
No, that's in Roswell.
Roswell.
It should be Fulton.
Oh, Roswell.
Oh, Fulton County. Yeah, it still be Fulton County.
Okay, so you're gonna report to the, is that a hotel?
I thought you were living in a hotel. Is that, yeah, it is. Correct.
Okay, so I'm gonna have you report to the Atlanta Probation Office.
Okay.
Are you familiar with that location?
I will find it.
I'm gonna give you the reporting instructions through the jail, but I'll
Okay.
also provide them to you here. You're gonna report to 276 Memorial Drive. That's Southwest Atlanta, 30303 within 48 hours of your release. Failure to do so may result in a warrant for your arrest. Do you understand?
Yes.
And again, I'll provide those instructions, a hard copy to the jail. Okay?
Okay.
Thank you,
Good
Officer
luck to you.
Evans.
Thank you.
Okay, great. Amberly has my number, so have her call or email me, okay?
All right, Ms. Rivers, do you want to take a quick break before we turn to the revocation matters, or are you good to go?
Need a quick comfort break.
Pardon me?
Just a quick comfort break.
Let's be back. My computer clock says 12:07, so let's just be back at 12:12, 5 minutes, and we'll dive into Wilson or Wright, doesn't matter. Whoever you want, we'll take care of those. So I'll see everyone in about 5 minutes. Thank you. Hold on one sec.
Excuse me, Your Honor. If you were talking for us to hear you, your mic is muted.
Thank you, Officer Evans. I wasn't yet, but we were about to start and that would have been awkward. We were talking about the trial calendar. And I just muted while we were on break so people could speak freely. So I need to put a big sign on my screen when I take a break. Mute. But someone was going to say something like really interesting about the trial calendar. No?
Oh, really
Okay.
interesting.
Does the resurfacing of Ms. Mercury change working out McGillicuddy?
I mean, I don't think it changes my offer. I'll take another look at it, but
Okay. I don't know anything about the case other than that now we have both defendants and gosh, it seems like it should be a non-complex, but here it is.
I think one or both are repeat offenders.
Yeah, no, it is. It's appropriately here. You're Mr. Wilson.
Yes, sir.
All right. We're going to get on the record in your cases in just a moment. Let me get. Wilson. All right. So this is 18 SC 160-777 and 18 SC 161-153. Both those cases are burglary in the first degree cases that you pled guilty to long ago. And you're on probation for both of them. You were on a probation calendar about a month ago here.
Yes, sir.
And we had to defer it to today, and Ms. Wood will let me know why. But importantly, the allegations in your probation warrant, there are a probation warrant for each case, are that in November and December of last year, you were instructed to report for a hearing. You didn't. You were referred to get substance abuse assessment to see if you needed treatment. And you didn't, and then you haven't been paying fines and fees. So it's a series of what we call technical violations. Let me find out from Officer Evans, who's with probation, how much time remains on your two cases. Officer Evans?
Yes, Your Honor. On this, on his 18 SC, on all three cases, the defendant has 4 years, 1 month, and 12 days remaining.
All right, you threw me.
Showing 3 cases, Your Honor.
I'm showing a second side to my calendar. 18 SC 161-154, another burglary in the first degree, although that one you supposedly had a gun as well. So you probably pled to all of them at the same time, and you've got a little more than 4 years of probation remaining with these alleged technical violations. Ms. Wood, why did we not tackle this back on May 29th?
Yes, Judge.
If you know,
So I
not
do
critical.
know. So this is one of the cases where he had worked with the non-complex probation attorney, and then it shifted to us. And then I had met with him prior to a jail Zoom calendar. And I was asking for something like 30 days revoked or 45 days revoked. And then Ms. Nix's recommendation was far larger than the amount of days I was requesting. And so it made more sense for me to have more time to talk to Mr. Wilson. And so that's why we're here today in person. So that's the background, and I will continue on if you'd like.
I can actually supplement that a little bit more. At that time, another revocation warrant had been signed but not served, I believe, for his new arrest in Douglas County for theft by receiving stolen property.
Yes,
And
now I'm
since-
remembering.
Since none of us knew anything about that,
Right.
we were gonna give us a chance so that the defendant would have notice about it, and also so that Ms. Wood and I could get some information about it.
See what was going on in Douglas.
Yes.
Got
And
it. So it wasn't just allegedly you missed some meetings, weren't getting a drug evaluation, but you got arrested in Douglas County. Let's see what that was about.
Yes, and I was able to get, actually able to get an offense report, and I provided that to Ms. Wood this morning.
So is there a probation warrant for the new offense also? Or what I want to know is if what we're resolving today will prevent Mr. Wilson from being hailed back into court for his 3 old burglaries if and when the Douglas County arrest catches up to DCS.
Your Honor?
Yes, Officer Evans.
I'm sorry. On the petition, it appears that the Douglas County arrest is on the petition for the
Okay.
defendant.
All right. Let me look. Maybe I didn't go far enough.
Yeah, I didn't see
down.
the petition, so.
Who said that?
That was 88
That's
Nick.
Ms. Who said that? Ms. Nix. Yeah, I just have the 3 warrants.
Oh, I thought
and-
I sent it to you, Judge.
Oh, so if you sent it via email, it may be here. I was looking at what Ms. Nelson had attached to the calendar. So give me a second. You've been firing a lot of things at me because we had a lot of you sent an email that said how long everyone had remaining. I've been asking you these questions. You already sent that. We just haven't worked together in this way, but now that I know you give me these care packages, I'll be looking for them. So there it is, 4 years, 1 month, 12 days, all 3 cases. And there's some petitions. So here's one. We'll just go with 777 because that's fun to say. Okay, I did sign petitions much more recently. They're from May 6th. The warrants were from December of last year. They were pretty soon after because they were the technicals. The guy's not showing up. You not showing up. The petition says violation number 1, don't violate the law. And it alleges that on January 4th of this year, you committed the new offense of theft by receiving a stolen vehicle and driving while your license is suspended in Douglas County. So that's the Douglas arrest. We are traveling under that. I've got a signed petition right here. 2, the non-reporting field visit, you weren't there, you didn't report, they called you, please show up, you didn't report. Violation 3 is get involved with a substance abuse program. You've been testing positive for THC, marijuana, and cocaine. You didn't report. And then you have some fines and fees you haven't paid. So they're sort of listed in the order that would concern me as well. You got arrested for something. You're not plugging in with probation. You're not getting some care, and then you're not paying. So those are the allegations we're working through today. And if we do resolve them today, Mr. Wilson's not at risk of there being another warrant or petition premised on the Douglas arrest. So with that, Ms. Wood, is Mr. Wilson admitting to these allegations, combination of admission and stipulations, or are some of these contested and Ms. Nix needs to call some witnesses?
We will stipulate, Judge, to the arrest in Douglas and the other violations in the petition as well.
Okay. All right. And what is it that you are recommending should happen?
Judge, so Mr. Wilson has been in custody since March the 15th of this year. We are asking the court to consider revoking 6 months of his probation and then reinstating for the remainder of the time he has left. Judge, Mr. Wilson has informed me he was released from DOC last summer. He's having a little bit of trouble getting reintegrated into society. I believe that's what's led to these violations. He has a wife, he has 2 children, he has a 10th grade education, and he was last working at, I think it's
Ego Smart.
Okay. So he's eager to take care of his matter here, Judge, and get back out. I will note this is the only thing holding him in Fulton County.
Okay, what about other counties?
I don't see anything.
Okay.
Okay.
It's the only thing holding him, period. Okay, got it. So revoke 6 months, obviously credit for I think it's 105 days, but however long he's been in, and then reinstate the balance. What are you going to do, Mr. Wilson, about, I'm pretty focused on you getting some drug treatment And so tell me your plan there, other than saying, I'll take care of it.
Well, from the start, my current probation officer, which was Officer Allen, she switched my probation officer to another officer. So that's where a lot of confusion came in with the assessment of the drug safety, because I didn't really know where to report to for it or whatever. But as far as the address, it's the same address, I stay with my baby mama, it's the same thing.
Is that the 375 Boulevard? Okay.
Yeah, so I know I made a mistake about such stuff, but as far as the charge, I called Douglasville, I bonded out on that, and I was just, my plan is to go and get back to work, and I made a slip up, but I'm really mad I made that slip up, because I've been in jail a long time for this slip up. So I wasn't planning on making. Like I said, I was driving up on the suspended. I didn't know my license was suspended, and then
Okay, I don't want you to go into a whole lot of the facts of the Douglas case, only because there's a prosecutor right there who could pick up that prosecutor hotline and say, hey, he knew the car was stolen or something like that. So,
but I've been locked up since January 4th, even though I came over here from Douglasville May 5th, March 15th. So altogether, I've been.
Oh, you didn't get out. You got arrested on January 4th, and you've been in continuous custody.
I bonded out March 15th from Douglasville.
Okay.
Fulton County came and got me, and I've been here since.
Okay.
So
I know you've been here because I got your booking date. Here you were booked in on March 15th. But I misunderstood what Ms. Wood was saying. I thought you get arrested on January 4th, $5 bond, you're out. And so you were out and about for 2 months.
No.
And then the probation warrant hit.
No.
Okay. So you've got it. That makes more
But
sense.
I have learned a lesson. I can't say that it was my fault, but I do plan to do better. And I know I don't want to go through this anymore, because I'm getting older and I got children, and I don't want to miss the time from them like this. I don't got no other charges in Fulton County. I've been sitting here 180 days in jail, 100 and some in Wright Street. So I'm just ready to get this over with, and I promise you, I won't come back in front of you.
All right, don't make these promises. So Ms. Wood referred to a wife, and you referred to a mother of your kids. Is this the same person?
Yes, sir.
It's not two women in different places. So when you talk about going home, your family, your household, that's the two kids, the mother of those kids, and that's that address on Boulevard.
Yes, sir.
How old are your kids?
I got a daughter 14 and a son 6.
All right. Does their mother work?
Yeah, she the manager for Pizza Hut.
Who takes care of them when she's at the Pizza Hut?
Well, she got an oldest son, older than mine. She's like 16, 17. So she don't leave till a little bit after he get out of school. So
but it's summertime now.
Yeah.
So the older one, who's almost an adult, I mean, he's pretty far in high school. He can watch that little 14-year-old probably can take care of herself.
Mm-hmm.
Okay. How long have you all lived in that apartment on Boulevard?
She's been living there about almost 3 years, but I've been living there since I got out of DOC last year.
Why were you in DOC?
Judge Down gave me a sentence of 10 to serve 5 for possession of a firearm by a convicted felon.
Just for that?
Yeah, and burglary.
Okay. Was it one of these cases?
Yeah, and you got the second case. That's the third case. Third case, you got the second case, and then I had a previous case before that. All of them are different sentences.
Oh, they're not all
the same.
You didn't plead on the same day for all.
That's why I don't understand. Why do I have 3 probation when each probation outlasted the other one? Like I had 5 do 6 months, for 7 years to serve 2, which you gave me like 14, and for 10 years to serve 5. So I'm thinking I should only have 1 probation with the 10 years to serve 5, because that overdoes all the other probation. So I don't understand why I have 3 warrants.
Well, Officer Evans, how is it that each docket has the very same end date?
I'm showing that they were sentenced all on the same day, October 12th, 2018.
Makes sense. Is there an older case for which Mr. Wilson is on probation as well? Like you have some other case?
Other than the case's name, no, Your Honor.
Okay.
I don't see Mr. Wilson on any other active probations.
All right.
Felony probation.
Got it. But I'm looking, so the first one ending in 777, Judge Downs, 10 serve 5, balance probated. So that's one. Let's look at,
There's also a 2014 indictment.
just want to see these other two.
So it looks like in
The
that
14 SC indictment ended in 2015.
That probation is all done?
Yes, Your Honor.
Okay.
there's a probation revocation order in that case from 2018.
Okay. So here's your situation, Mr. Wilson. I don't know about those other cases, but the 3 cases we're talking about today, they're all 18 SC. They end in 777, 153, and 154, all burglaries. Judge Downs sentenced you on all 3 of them on the same day and gave you 10 years to serve 5 years, balance probated. Those 3 cases all ought to have the same amount of probation remaining because they're all moving together. And that's why you've got 4 years, 1 month, and 12 days. So these other cases you're talking about, you're not on probation for them. You're on probation for the 3 Judge Downs cases. And that's it. And this math makes sense to me. In some ways, it doesn't matter. You got 4 years left, and you're going to make dumb choices or good choices as you go forward. The dumb choices are going to lead to these unhappy consequences where the mother of your kids is having to juggle a lot, and you're sitting on your hands at Wright Street or Douglas County Jail. Okay. That's helpful to know. Let me turn to Ms. Nix, your thoughts and recommendation.
Yes, sir. The defendant has a long history of property crimes that may be related to drug use because of some of the conditions that were in his probation, including RSAT, outpatient treatment, halfway house. And it looks like he is not completed any of those opportunities that probation gave him to try and address the root of his criminal behavior, and then committed a new offense in Douglas County earlier this year. That was a theft by receiving stolen property of a U-Haul, and he was driving without a valid license. More concerned about the stolen U-Haul, but so I am not sure how the DOC RSAT works, how much time a person has to have. But I would recommend that, or that the defendant's probation be revoked for at least 12 months.
Okay. Officer Evans, when is the last time Mr. Wilson had, if he has had a revocation hearing in connection with, well, I guess when did you get out of DOC?
August 8th, 2023.
Okay, you didn't have time to do more. You're pretty new to probation, which is why there's so much left. Okay, that makes more sense. So you got out, you started probation, you were missing some meetings, you were testing positive, you weren't getting your abuse evaluation. Then you picked up the Douglas case. All right, I think I understand all that. So I'm pretty focused on you getting some help with drug abuse. One way to do it would be to require you to do the Metro Atlanta Day Reporting Center. But that's every day, not weekends, but it's Monday through Friday. And for the first couple months, it's a whole lot of each day. And so if you're thinking, I'm getting out and I'm going to go work, you wouldn't be working 9 to 5. You could work on the weekends. You could work some on the nights, but you can't sleep through the day reporting center. Pretty quickly, a few months into the day reporting center, it shifts to being more in the evening so that you could work during the day. But it is basically your job if you do the day reporting center. I think that's one way to show you and your family, me, insofar as you care, what I think, that you're serious about taking care of yourself and being responsible but I don't want to require that if you know that's not gonna work for you. But you're gonna need to get some form of drug treatment soon so that you don't fall back into this cycle. Because
like I told you, sir, they had a drug assessment class they wanted me to report to on Thursday, but I couldn't really get the full detail of because the probation officer said she switched my officer from Miss Allen to Officer Newby. So at that time, it was a big confusion about that part. So
I heard you say that, but that's kind of unimpressive because then you just keep calling them. And if you can't figure it out, you go to the probation office. Like, what the heck? I have this new officer. I'm supposed to get a drug assessment. And what happened instead is that you stop showing up and then you're driving in Douglas County without a license in a stolen U-Haul. So it's sort of a worst possible outcome for you. I just want to know what your thoughts are about the best way to get you drug treatment. Do you want to do the day reporting center, or does that sound like that's a little much? Because I know I got my own thing going on.
It's a little much because I really need to work and provide for my family. But at the same time, see, I hear what you're saying about I can work at nighttime. But if I get a chance, I just know I got to report to the drug assessment class or whatever they're trying to do for me at the probation. I just know that's what my first and foremost got to be. If they want me to take a class or whatever, or assess me to see if I need drug treatment, then we can go from there. But I don't think I need a Metroland Day Reporting Center just because, like they said, they were trying to see, do I want assessment? I mean, assessment. They were trying to.
I'm not interested in whether you want it, but let's do a little role playing. I'm now your drug abuse assessment guy. Hey, Mr. Wilson, how you doing? I'm Mr. McBurney.
How you doing, sir?
So what kind of work are you hoping to be doing?
I'm hoping to do factory work, like be working construction or either a factory for right now till I get enough money saved up to go back to school to get it to like a trade. Hopefully drive trucks.
Have you done that kind of work before, working in a warehouse or construction?
You go smart.
All right. You tested positive a few times with us here in probation. Tell me what drug or drugs you feel like you struggle with the most, the things that kind of get in the way of you achieving your goals.
But like you said, sir, I just got out of prison doing 5 years. Before I went to prison, I struggled a lot with drugs. But in my stay in prison, it's hard to get drugs.
Good.
So when I got out, I wasn't really dealing with drugs like that. Like a couple pills, okay. I'm admitting I take a couple pills. Marijuana, I probably hit a blunt or two. But as far as just
not hardcore
using, I wasn't using. I was actually balancing myself way better than what I was doing before I went. I ain't catch no. And my record shows that I don't call it plenty of burglaries, plenty of other cases.
It does show that.
But I ain't been catching nothing serious like that since I got out. Like, I've been trying to keep the right path.
Before you went down the road for 5 years, what was it you struggled with the most?
Cocaine.
Cocaine. Okay. All right. So you did well in your drug abuse evaluation. All right, Mr. Wilson, I find that you violated the terms and conditions of your probation in all the ways that are set forth in this most recent petition that I signed. So you were arrested. I'm not saying you're guilty of the Douglas crime. You need to deal with that. You'll have court dates. Don't miss those court dates.
Mm-hmm.
You certainly are responsible for not showing up, being kind of hard to find for probation. You need to be super easy to find. They need to have all your digits, your number, your the mother of your kid's number, your mom's number, whoever, so they can track you down.
Yes,
sounds like your address is very stable.
Yeah, they were pointing. I was seeing them there.
Okay. You also are going to need to submit to, as in sit down for that drug abuse evaluation.
Yes, sir.
Because you haven't done that. And then finally, there's some fees or fines you haven't paid, but you'll do that as you are able. Okay.
Yes, sir.
Given those violations and your criminal history and how quickly you racked this stuff up after you got out for serving some time, I'm going to revoke 9 months. You will get credit for the time you've done since January 4th of this year.
Yes, sir.
I will reinstate the balance. And in case it's not clear, it is a special condition of your probation that within 30 days of your release,
yes, sir,
you have submitted to a drug and alcohol abuse evaluation.
Yes, sir.
It's a special condition of your probation that if that evaluation results in any treatment recommendations, that treatment becomes part of your probation.
Yes, sir.
I I think that's it for the issues we were talking about. Other conditions you'd want to see added, Ms. Nix? Judge Downs already had, whoops, that's the wrong screen.
You just.
Oh, GED, you're supposed to you're supposed to do that while you were in prison. Did you do that?
No, sir.
Well, we had 5 years. What were you doing?
Well, you know, at first the camp I was at, they didn't have GED classes. Then I got shipped to another camp, and it was just level 5. I had it. It was more about my safety than anything getting home. So I'm sorry about that.
Well, you made it. I'm not mad. That's what she said that. So I'm gonna add that as part of your probation is that you need to enroll in a GED course. You need to have enrolled within the first 6 months you're on probation.
Yes, sir.
If in the end that just doesn't work for you, and sometimes GED doesn't work for someone, then let's talk about it. That's not the kind of thing I'm going to revoke you for in the future.
Yes, sir.
It's not going to hurt you to get your GED. It's going to help with you wanting to get a CDL and all these things you want to do.
Thank you, sir.
So that's not a punishment. That's a betterment thing. And finally, I'm going to waive your probation supervision fees for the first 2 months after you get out, so you can get on your feet. And I know, what's the last name of the mother of your kids?
Marshall.
Marshall?
Yes, sir.
Because Marshall, I am sure, is going to be saying, yo, Wilson, where's some money for the family? So you're going to want to get back to work. And so have the money go in that direction. But after those first 2 months, your supervision fees will be back in place. Do you have any questions about any of that?
Can you just make sure my paperwork get into the jail so I can get out as soon as possible to be with my kids?
Yes, sir.
Because this kind of process with probation, they kind of release you like 5 days later or whatever. I know you say I get credit for time served in January.
Yep.
So that means I should be going home soon.
Soon, yes. But I promise the paperwork will get in before your release date. Okay? Officer Evans, do you want to give Mr. Wilson reporting instructions, or how do you want to handle this?
Your Honor, I wanted to also bring to your attention that the defendant may be eligible. Let me put it like this. Would you like the defendant to continue on active probation for the remainder of his sentence?
Thank you for flagging that. I saw that note in the final disposition, but given how things went the first few months, let's keep Mr. Wilson on active probation. We can always revisit it in a few years if everything is going well.
Yes, Your Honor. And just reporting instructions. Mr. Wilson?
Yes, ma'am.
Are you still at 375 Boulevard?
Yes, ma'am.
Okay, you're gonna report to, do you have Officer Simmons' contact information?
No, ma'am.
Okay, you're gonna contact Officer Simmons at 404.
Yes, ma'am.
227.
Yes, ma'am.
2248 within 48 hours of your release. Failure to do so may result in a warrant for your arrest. Do you understand?
Yes, ma'am.
If you're unable to contact Officer Simmons, just report to the Atlanta Probation Office.
Yes, ma'am.
Good luck to you. Thank you.
Thank you. Thank you.
All right, Mr. Wilson, that takes care of that. This will be the same revocation order in all 3 of your cases, identical. Okay.
And I do get time served on January 4th, right?
I promise.
Okay. Thank you, sir.
All right, there it is.
Thank you.
All right, good luck to you, Mr. Wilson.
Yes, thank you.
All right, we have a little more than 10 minutes. If you think we can do Mr. Wright in that, we will. Otherwise, we got to like 1:20-ish. I'll come back.
I'll be quick.
All right. Well, it's not always just you, but if we could bring Mr. Wright out, please. All right, let's get on the record in 14 SC 129629 and 15 SC 134562. These are both Randy Wright's cases. Mr. Wright is here in court with his lawyer, Ms. Wood. Ms. Nix is here in court. And Mr. Wright, you have a little more than a year left of probation on both these cases. And you are here because I signed petitions in your case in April of this year that allege that in July of last year, you here in Fulton County committed the offense of possession of a firearm by a convicted felon, a little bit of marijuana, and driving a car without a license. And
Registration.
or registration, right? Exactly. It says registration, not license, that it was a no good registration. And then more recently, March of this year, you had again misdemeanor marijuana, and then maybe you had some methamphetamine. So the violations are both new criminal conduct. One of them's not so new. You were being supervised out in Douglas County. I guess that's where home was, but it comes back here because I'm pretty sure these weren't my cases, probably Judge Downs's cases when you were originally sentenced, but I have her docket now. So that's what we're working through. Ms. Wood, tell me, is Mr. Wright admitting to these, and sort of what's the status of these two sets of charges?
Judge, we will stipulate to those arrests. It looks like the 23 CP 220441 possession of firearm case is still pending. The other case, the 24 PI 002276, was dismissed at the April 23rd preliminary hearing for officer not showing up, so that one may reappear. Judge, he's been in custody since March the 31st of this year, so 89 days. We're asking the court to revoke 6 months and close out his probation. He's 41 years old. He's a lifelong Atlanta resident. He has 6 children. He's a high school graduate. He also attended college at Grambling State. He can live with his mother at 3276 Elm Street in College Park. And Judge, he does have a hold out of Jonesboro. I believe that will be a misdemeanor. It's a traffic ticket issue.
Okay. So 6 months and close it out. He may yet need to deal with one or both of these sets of charges, but there's only one that's pending in the form of a complaint.
Yes, Judge.
I think I understand that. Ms. Washington, how many cycles does Mr. Wright have?
All right, bear with me one moment. I have 20 arrest cycles for Mr. Wright.
Okay, and what's his most recent conviction?
The last conviction I see is for a misdemeanor for criminal trespass, and that was out of Douglas County, and that was May 5th of 2019.
Got it. Okay, thank you so much.
You're welcome.
Ms. Nix, your recommendation.
Yes, sir. The defendant is on probation for 2 pretty serious charges, one of which is the aggravated stalking. This is his 3rd probation revocation. The first 2 appear to be based on technicals, but since being on probation, he has been arrested for 2 new felonies. One involves him being in possession of a firearm that was a shotgun that was in a car that was stopped. He was the driver and admitted to officers that he was just holding it for his brother. He's got also the other new charge of willful obstruction of law enforcement officers and possession of methamphetamine. While these 2 new charges are not as serious as the charges he's on probation for, they still show a disregard for the criminal laws of Georgia. And so the state's going to request that you revoke the balance. I understand it's just a little over a year. So if we can do just 12 months and then suspend the balance.
Okay.
And Officer Hill in the 23 CP case was going to be here this afternoon to testify to the underlying facts of that case. But I did call him off based on Ms. Woods telling me that they were going to stipulate.
Good. I appreciate you giving Ms. Nix that heads up, so we didn't need to have the officer here. It sounds like what the officer would testify to was driving the car, shotgun in the car, and Mr. Wright saying, "It's not my gun, but I'm, of course, holding it, I'm possessing it in the sense of I'm driving the car and I know whose gun it is." Not that the officer removed it from his waistband or something like that. That'd be a
It was a shotgun, so to have it in his waistband. But yes, sir.
Be a big waistband. Okay, thank you. Anything else, Ms. Wood?
No, Your Honor.
All right, Mr. Wright, when you are released, it sounds like you're not going back to Douglas County. What's your Douglas County connection?
I was living in Douglas County. I was serving probation out there, but I've recently moved with my mom.
Okay, did you have family in Douglas? Or you had your own spot?
I had my own place.
Okay, does your mother know that you would be staying with her?
Oh, definitely.
Okay, and she's all right with that?
Yes.
Okay. All right, and I asked just because sometimes it's like, no, I haven't told her, but she's my mom, so she has to take me.
She's supposed to show up today, but
Okay.
I told her 1 o'clock.
Something may have come up, and we're going a little early, so if she makes it, we'll let her know. Okay. Your kids are all grown?
No, I have 18, 17, 15, 13, 10, and 9.
Okay, none of them is grown. All right. I don't think that's your mom. No, okay. No, it's fine that you came in. He just said, my mom's coming. Like, I'll bet you dollars that's not mom, but things happen. So, okay. Mr. Wright, you are on the home stretch with these cases. Ms. Nix is exactly right. These were scary cases, but they were a while ago. And you seem to have turned some corners, not all the corners you need to turn. You may need to work through some drug use issues as well. It's not going to be while you're on probation. I do think it makes sense to close this out, and we'll do that. I'm going to revoke 9 months of your probation, give you credit for all the time that you served, and then close the case out. So you'll be in for a little while longer. As I said, you'll get full credit, but when you are released, you don't need to report to probation. There won't be any further supervision there. I don't know what's going to happen with your 2 newer cases. The state may decide to just drop those because they've got more important things to work on, but they may indict both. Even the one that got dismissed, it was dismissed not because a judge said there's nothing there. There was nothing there in the witness stand. And so you were entitled to have it dismissed because the officer didn't show up. Okay?
Yes, sir.
All right. Ms. Wood, anything else on behalf of Mr. Wright?
No, Your Honor, thank you.
Ms. Nix?
No, sir.
Okay. Officer Evans, do you need anything else to do the order?
Nothing further, Your Honor.
All right. Thank you.
Thank you, Judge.
You bet.
All right, I will hand this to the deputy when I get done with it so that you'll just have it. Okay? And I'll give your mom a call and let her know.
Okay.
Good luck to you.
Can you pronounce your last name for me, please? Ma'am, Leslie M.
Merca.
Say it again.
Merca.
Merca, Ms. Merca. All right, I'm Judge McBurney, and we were looking for you yesterday. We're not going to talk about the substance of your case because Ms. Brown, your lawyer, hasn't dialed in yet. She's not late, but I have to get on a call at 1 o'clock. How did Ms. Brown find you? Because she said she was calling and trying to connect with you, and
My phone number had changed, and I've got so much going on right now. Like I just forgot to text her because.
Okay, hold on. She just joined the call, so we're going to be able to have her. Ms. Brown, if you're excellent, there she is. Let me add her, and we can remove this. Good afternoon, Ms. Brown. Thank you for joining us. You did great detective work. You should be a detective as well as a defense attorney. I want you to know, all I had asked Ms. Merca, I actually hadn't asked her anything yet. I just explained, we were looking for her yesterday. You had represented that your normal ways of contacting her hadn't worked. And I impressed upon Ms. Merca the importance of not talking about the substance of her case, but that I had to get off this Zoom call in just a moment. But you're here, so I think we can close the loop. Do you, Ms. Brown, now have good contact information for Ms. Merca?
Yes, I do.
Does
I have
that
her cell
include?
number, and she has my cell.
Okay. What about email?
I have her email as well.
Okay.
Or her mom's email, one of the two. Is it your mom's or yours?
It's mine. It's carolmerca@gmail.
Okay.
Okay. So she's got email and she's got a new phone number for you. And
I updated her address as well.
fantastic, because that's what I was going to ask next. I'm pulling up. The change of address is already filed. So is that the Cook Road in Stockbridge?
That's correct.
Okay, good. So you will get notice. Then I think we're all right. I have not signed the bench warrant yet, and I will not sign the bench warrant. We'll just throw it away. But Ms. Merca, this is your one pass. You need to keep Ms. Brown posted. You can move, that's fine. You can change your phone number, and that's fine. But Ms. Brown needs to know that so she can push it into the system. And that way we know you will always make it to court, either virtually like this or in person, because we are trying to move your case along. Your co-defendant is actually on a trial calendar coming up in about a week. And we're going to try to catch your case up soon, but obviously it's not on the trial calendar for July 2. Ms. Brown needs to spend some time with you on the case. Ms. Brown, do you have the discovery? I don't remember what week.
No, I don't have the discovery. So if you know who the ADA is.
Yeah, it's me. I'll get it to you.
She's right there. That's Ms. Nix in the kind of, what color would you call your blazer?
Pink.
Pink. All right, we'll call it pink. The pink blazer. She will get you discovery, Ms. Brown, and then you can get with Ms. Murky on what's in the discovery and what's not and all that. And so maybe we'll just get a scheduling order in place. Did you do a waiver of arraignment?
I did a long time ago, I want to say.
Okay. Well, I think I'm going to get with Ms. Nelson. We'll figure out how we're going to handle it, whether we'll do a new scheduling order or just go with the flow. But I'm anxious to have this case pick up some speed consistent with your schedule. So step one will be get you discovery, and then we'll figure out if you've got any motions, and we'll take it from there. Ms. Murky, do you have any questions?
I do not. You said, okay, so my co-defendant has a trial hearing next week, you said?
Well, we call the calendar on July 2, but we actually bring in jurors on July 8.
Okay. That's my son's birthday. Do I need to be there?
If you get a subpoena, you need to be there, but it's not your case, it's his case.
Okay, got you.
He's got a different lawyer, happens to be someone you can see on the screen there in the blue blazer. That is his lawyer, and he may work his case out. He may not go to trial, or it may be that the decision we make is tap the brakes on his case so that the two of you are moving forward together. I'm not required to do that.
Okay.
And certainly if Mr. McGillicuddy wants to work his case out, he can do that. Ms. Brown will stay plugged in. She'll be talking, I'm sure, with the person in the blue blazer who just stepped out of the camera, as well as the prosecutor, and we'll see what happens. Okay?
Thank you, Ms. Brown.
Thank you. No problem.
All right. You guys are free to go.
Thank you, Your Honor.
Take
And I'll
care.
be hearing from you, Ms. Brown?
Yes.
Okay.
Thanks,
Thank
Judge.
you. I'm so sorry. I'm so sorry about the contact issue.
All right. Before you go, hold on one second. Yes, Ms. Nelson.
I was saying, thank you, Judge, for working this one out.
Oh, you're welcome. All right. Everyone's welcome. You're free to go. And that concludes our calendar. So thank you, Ms. Washington, and Officer Evans. I will see, I know Officer Evans next week when we've got calendars, and whoever we will luck out with from pretrial services.
Oh, Your Honor,
Yes.
I will not be here Monday and Tuesday. I'm actually on vacation next week, but the following week I will be here.
Fantastic. All right. We'll limp along till you get back.